Good morning. When the House rose last night, we were on the third reading, the Resource Management Duration of Consents Amendment Bill. We're on call number 3, Larn Farm.
Morena, and a holly jolly Merry Christmas morning we have this morning. Although we are in yesterday in this urgency, so it makes it a little bit weird. I wish I could say I was feeling the Christmas spirit today. I really wish I could. But the unfortunate thing, Mr. Speaker, is that we're starting this long day of urgency with nothing but a lump of democratic override, delayed environmental protections, and more pollution for Kiwis for Christmas. And I think the really disappointing thing that we heard throughout the committee stage was this constant denial and downplaying of the actual impacts of this bill. We heard from Minister Bishop, you know, it's just a bill, it's only 5 clauses, it's not that complicated. And yet it was so clear throughout that the understanding of the very real implications is just completely absent. You know, we don't know the actual implications when it comes to exactly how many consents, exactly what the environmental impacts will be of this delay. And there was a real incoherence and total lack of understanding within that about our existing resource management system and the people and the resources that go into actually making it work. We haven't seen that or heard that at all, or an acknowledgement of that. So I really want to take the time in the wrap-up of this third reading to acknowledge those people, particularly those council staff, but also those fantastic landowners and farmers who know and understand the importance of environmental protections and are actually getting on with the job despite anything that this government is doing. Now, we also heard from Minister Bishop that we're effectively doing to consents what we've already done with plans through the plan stop, relieving everyone of the burden of going through the motions with a major overhaul looming. But what that government is actually doing is leaving everyone else to continue to live with the burden of the impacts from the activities that happen in their communities. And a lot of these perhaps never should have been consented in the first place, or we're finally getting to the position where they would be renewed, where actual rules and regulations that exist within our district and our regional and our unitary plans would actually have some effect. And that's not just for a bureaucratic exercise, that's actually because we know we're losing biodiversity and we continue to lose it. We know we're losing, you know, these last remaining dry land pockets of minute indigenous vegetation and kōwhai. You know, these are the unseen impacts of this bill, and communities will now have to live with those impacts for another 5, maybe 6 years or longer. So what we find extremely disappointing with this government's pushing through the urgency of this bill is the power that is taken away from communities where in many instances, and particularly with iwi and hapu, we're finally about to be able to have a say, be able to contribute, whether that be through their own voice or through the voice of the democratically landed plans that actually wrote those rules and regulations that would have had impact. So instead we have this complete and utter overreach from this government, and it actually says everything it needs to say about the government, they seemingly have zero understanding of a duty of care that New Zealanders actually expect from government, no matter their stripes, of actually protecting te tai, our environment, and the value of local voice. You know, the government waxes lyrical about localism and then takes all the power away from those local communities. What's really damaging, and I'm hearing from the government that they want to hear something positive. Well, I think the positive thing that's going to come of this is that the communities across Aotearoa are seeing exactly what this government is about in terms of destruction of te tai, continued exploitation, and they're going to take the opportunity that the next year brings to vote this government out. That's the positive that I'm taking from this. Hallelujah. Because no matter what this government does, for people, for farmers, for landowners who actually understand the world, the environment and their markets, they know that where we're going and where we're ultimately evolving as humanity on this planet is towards increased environmental protection and connection and understanding, not less. So this is a rallying call for everyone out there who rejects what this government are doing to get involved. So that's the positive that I want to take from today. They also say that this will give certainty to consent holders. So certainty to consent holders, councils and communities while the RMA is being replaced. And that is bang on, because it will certainly be the status quo continuing. It means certainty for those many communities across our country, places like Waimati, like Selwyn, like Kyle up in the north, that their water supply will continue to be undrinkable because of pollution, primarily from intensive agriculture, wastewater systems, stormwater systems. It's all one bundle. It will mean certainty this summer for New Zealanders who go out and think they can safely swim in their rivers and lakes, and they either get sick or if they're, onto it enough to actually check, find that their local river, lake or beach is actually unswimmable. And it will certainly mean certainty for the declining trends that we know exist, with more species at risk of extinction, more communities struggling to pay for clean drinking water, and more valuable soil washed off our hillsides. Ultimately, this bill and the next steps that it provides for, this replacement of the RMA based on private property rights, will give New Zealanders certainty that soon enough, what someone wants to do with the land that they have the influence to make decisions on, whether they're the overpaid CEO of large milk processing companies or a mining executive or industrial farmer or, simply a neighbour, those private property rights will be more important than the activity that might have and the degradation and the exploitation that it will have on the communities and people downstream or in proximity to them. And that is absolutely not acceptable. If farming operators want to intensively farm, the nutrient pollution that leaches into the groundwater doesn't just remain there. It impacts everyone around them. It pollutes the groundwater. We know this. We know if someone strips the native forest on the hills of their property, the soil that washes down in the storms doesn't stop at the property boundary.
That's right.
It carries downstream, it carries on to communities with sometimes devastating impacts. We know that if landowners plant pine trees on steep land and clear fell them in one harvest, the logs and the soil don't respect property rights. They impact all of us. This bill is just one of the many government's short-sighted, ill-thought-out, destructive attacks on even the most basic protections that we have remaining. And it can be really hard within this to remember that a better future is possible, but we're staying focused and New Zealand should know that it is.
The Honourable Andrew Hogarth.
Thank you, Mr Speaker. Well, some good news. I just remember previous mentioned about can people swim. I just did a quick check. It's 28 degrees on the farm yesterday, I was told, and had a quick check of the Lawa site, and yep, daughters are free to go swimming in the river. It's all good, and it looked like the rest of the Manawatu was as well. So it's not all doom and gloom. Now, in terms of this bill, it's a very simple bill. We've got a fundamental change coming up with the RM system. We are completely changing it on its head. We are moving to a new system. It makes absolute sense that we take the current consent holders and transition them through into this new system. I don't know whether members have seen the various accounts of how much it is costing people to get a simple consent renewal, but that's tens of thousands of dollars, sometimes hundreds of thousands of dollars to go through this process, all for what? It's not making the environment any better, it's making lawyers richer, but it ain't doing much for the environment. So this just makes complete and utter sense. Member also mentioned about, the fantastic farmers that are out there. Well, these are the people I've been meeting. These are the people that are facing these huge costs. You don't believe me? Feel free to send me an email. I'll give you the names and addresses. You can go visit them yourself and see the absolute wrenching process they've had to go through, and absolutely fantastic farms they're running just to try and get a consent renewal to keep on doing exactly what they've been doing, and in many cases getting awards for it, getting A-grade reports. This bill just makes absolute sense, and I commend it to the House.
Jamie Arbuckle.
Thank you, Mr Speaker. I rise on behalf of New Zealand First to support the Resource Management Duration of Consents Amendment Bill. And in the first reading, the Honourable Mark Patterson, he mentioned what a big week this is for New Zealand's future, and it is a big week, and this is a part of that legislation that will make such a difference going into 2026. It is a turning point in this environmental legislation and renewing the law as we go forward. It's also taking a blowtorch to the red and green tape that we see that is holding up business in development within the country. But Mr Speaker, as we heard from the last speaker, it is a simple bill in the fact that it's a 2-year extension. It gives to the 31st of December 2027 to the RMA replacement legislation comes in. So what that does, Mr Speaker, is gives some certainty. It also helps around costs, so people aren't spending unforeseeable amounts of costs on the old broken RMA. And both sides of this House get up constantly and say how the RMA 1991 is broken. So why would we want to force people to go through that system if it's a broken system when we've got something better just on the horizon? That is the reason we give this extension here today. So the other thing, Mr Speaker, we hear too often from the opposition, from the other side of the House, that everyone seems in New Zealand that's got a resource consent for some reason is a villain. They're not. They are genuine people trying to get this economy moving and trying to grow the economy, and this side of the House is getting behind those businesses and supporting them. That side of the House is being unhelpful. They're adding cost and uncertainty by making them go through a broken system. They actually sound like the bureaucracy we're trying to get rid of, and that's the reason they'll still be in opposition in 2026 going into 2027. This opposition, they don't care, and we do care on this side of the House. We will grow the economy. This is a good piece of legislation, and I commend it to the House. Thank you.
Nā koe, Te Pika.
Debbie Narawa Paka.
You know, the hardest thing is not just having this whole debate under urgency, but is also reconciling the myth plus the legend and a whole lot of Disney kōrero that's been going on in the last 12 hours. what it is that the biggest discussion here, the fundamental principle of what's going on is that there is an assumption that everyone that has a consent is best practicing, that they have best practicing environmental aspects to their business, to their thinking, to their culture, to their way of being. But that is not the case for many. For many, this bill has interrupted those who have survived Mururaupatu, and we're expecting to have consents concluding and justice served. That is not what is happening here. In many situations, we have people who have been absolute great citizens of Aotearoa, who have honoured te tiriti, who have honoured settlements, and are protecting the awa, Waikato awa, who are concerned with the extraction that consents are doing. In many situations, these are great partnerships and great examples for Aotearoa to show those iwi, those hapu, those leaders of community Māori, that have gone and worked with their councils, that have gone and agreed on what can be the next movement within these consents, but they're no longer going to end. And that is the fundamental argument here. Not as that there are some good farmers, not as that there are some good practicing companies. The fact that the law was meant to protect us all. And by extending this, that has been taken off every other citizen who has absolute right to be able to conclude some poor practicing companies with really bad consents. That is what's at stake here. And I think, we need to go back and remind our whānau out there what consents look like. So what this government has said is that those who are not best practicing in polluting discharges, those who are not best practicing in industrial emissions, those who are not best practicing in stormwater runoffs, in land use, in coastal permits, in marine and coastal structures, those who are not best practicing in how they have applied their way into infrastructure projects are now given an extension. That's the debate. And we should all be applauding those who are best practicing. I certainly do, and have some great farming practices. We're all shareholders in PKW, great farming practices, great land use, but not everyone is in that situation. And that's where this bill has desperately let down those communities. They have spent years, generations, protecting and expecting justice. And this government, in the interest which we continuously hear of economic development, has told those iwi, those hapu, those communities to go and forget what we had said we would do, which is treat all of Aotearoa equally, all of Aotearoa well and with justice. And that is not what this bill's doing. You can sit there and say it's complex, but the government can sit there and say it's complex, but it actually isn't. And why is everything that has to be about justice and economic development involve removing treaty relationships, involve removing the goodness and goodwill of iwi, involve taking out hapu? Why? Why can't we sit here and be a government and be a country and be a parliament that actually sits here and says, you're right, we honour te tiriti, we honour the great partnerships and the leadership that's happening out in the regions, that's happening out locally? No, why is it that everything that involves economic development, everything that involves cleaning things out in this government also means moving and sidelining Māori? Why? That is the problem here, is that this government has told all those waiting for generations across consecutive governments that you do not matter. Your consent issues do not matter. Your pollution issues do not matter. The fact that your wahitapu and your ability to want to develop does not matter. But by goodness, Māori, you matter when we want economic solutions. You matter when we want to make sure we have great partnerships with your dollars, but your principles and your values are thrown and sidelined by this government. That's what this bill is doing. And only this government will be able to confront the wrath of iwi and many who are having to unnecessarily spend their time in courts, undoing the damage that this has done. This was about honouring, and this government has honoured and sat there and agreed to every treaty settlement that has come through this House, every treaty settlement, but in one swipe, under urgency, without even allowing them the dignity of a kōrero or a conversation, you have decided to sideline their interests, sideline their intergenerational fights, sideline the fact that they have rights to be able to respect this taiao, and you have sidelined every other New Zealander that cares about the future of the mokopuna. Shame on this government. Kia ora rā.
Steve Abel.
Thank you, Mr. Speaker. I would wish to remind the House and the member Jamie Arbuckle that it was his government that reinstated the RMA at the beginning of this term, after the previous government had created a whole new piece of environmental legislation, the Natural Built Environment Act. And so what was announced yesterday, Mr. Speaker, which is the reason for this piece of legislation before us today, was a radical inversion of the principle of the purpose of our primary legislative structure around the environment to be the protection of the environment. And this government has now created a situation where public officials will be spending the best part of 6 years rewriting environmental law because of the time spent by the previous government and the time spent by this government. How does that give certainty to the public or to industry? Minister Hoggard said that the new RMA, just now in his speech, completely turns it on its head. It does. It does, because it says that private capital should be the primary focus of our environmental regulatory system, not the environment. This law before us, this bill which extends the consents, like so many things that come to this House under this government, has had exceedingly little evaluation and scrutiny. There is no accompanying regulatory impact statement. The Ministry for Regulation has not exempted the proposal. The urgency with which this legislation was prepared did not allow time for a regulatory impact statement to be developed. Several thousand consents have recently expired or are likely to expire next year based on the limited data available, while we don't have exact data. The urgent timeframes for preparing this legislation have constrained the ability to undertake a broader analysis of the magnitude of the costs and the benefits. This is all in the departmental disclosure statement, and the cost to the environment has certainly not been evaluated. Because this government fundamentally does not care about that cost. It is imposing on us a new radically right-wing property rights above the commons, above the public good, above the founding principle on which our nation is based, Te Tiriti o Waitangi. It is opposing a new form of, actually Mr. Bishop in his responses to questions last night used the term anarcho-libertarianism. In fact, the correct term for it is anarcho-capitalism, whereby you place private property at the centre of all considerations and you enforce the rights of private property. What's the problem with that, Mr. Speaker? Well, I tell you what the big problem with it is that the commons don't belong to anybody. The atmosphere doesn't belong to anybody. From the mountains to the sea, the rivers, the lakes, the aquifers, the oceans are not the possession of anybody. So how can you protect them through upholding private capital and property rights? You simply can't. The only thing you can do through that is allow the greater destruction and exploitation of them. If you've got the loot, you've got the right to pollute. And if you say that private property, which is capital, is a basis for a right, then the simple fact is if you've got more money, you've got more rights. And when Mr. Bishop gives the example of somebody putting a garage on the front of the house, that makes it sound like it's not actually about giving extraordinary extra rights to major corporations in this country. To say that if I'm going to tell Fonterra they can't put so much nitrates into our rivers, I better compensate them for it. I better compensate them for the regulator and the legislator doing their duty, which is protecting the commons from those who would destroy it, for the good of this generation and future generations. That is what environmental law should be based around. This extension is just a pathway to a Ozymandian hubris.
Katie Neiman.
Reverse everything over the last wee while. I think what is very important to say here is there is nothing more local than individuals in a community getting jobs done, doing the things that are very important for them. And I think that what has been said opposite is an insult to the council planners, consent planners that have put a huge deal of work into what's been done in the first place. This is making sure that every single one, and I said this last night, has certainty to keep going over the next 2 years while we go through the upcoming process. It is important, and I commend this bill to the House.
The Honourable Priyanka Radhakrishnan.
Thank you, Mr. Speaker. Quite a few things to traverse in the third reading of this bill today, and I want to make mention of some of the comments that members opposite have made, particularly Jamie Arbuckle, who claimed that those of us on this side who are speaking in opposition to this bill hold a view that those who hold resource consents are villains, and that is absolute nonsense, Mr. Speaker. There is nothing that is further from the truth, and I will lay out in my contribution to the third reading of this bill why that is so. Firstly, I will make the point, though, about the process that we've debated this bill under. It's been under urgency, all stages urgency, for a bill for which, while this may be a transitional bill, it provides, according to government members, some certainty for those who hold resource consents. But there was actually no need, firstly, for this bill at all if the government had got their act together and done a better job with the RM reform that they campaigned on. And secondly, I still don't understand, although we've gone through pretty much all stages of this bill, including a committee stage of this bill, why the secrecy for this bill? Is it just that the government couldn't get their act in order? Did they not foresee that this was going to happen? I mean, the bill, was introduced to the House a very short time frame before we actually debated this bill for the first time, to the point that when we read the bill and we clicked on the link to the departmental disclosure statement, the link was broken, and we couldn't actually get the DDS till we were in this House and we picked it up off the table. I mean, why this level of secrecy? We didn't know what the first bill was that they were going to introduce under urgency, and it was this one. A transitional bill that apparently just provides some certainty for resource consent holders. Did they not see that this was coming? And to my other point that I sort of laid out at the start, that there is actually no need for this bill at all, we spent a fair bit of time, Mr. Speaker, and we understand the need for faster consenting processes. We understood the fact that the RMA wasn't working in terms of consenting or protections for the environment. In fact, we repealed it, Mr. Speaker, and we replaced the RMA with two bills, which was the Natural and Built Environment Act and the Spatial Planning Act. Now, this government took office in 2023. One of the first things they did was to repeal, in December of 2023, those two bills. They have now taken 2 years to come up with two bills of their own, which to an extent mirror the legislation that Labour and government brought into play, that we had worked on over a considerable number of years. The main difference between their two bills and the ones that we introduced to replace the Resource Management Act is the emphasis on property rights. And that is the bit that is going to be problematic. But members can judge, members of the public can judge whether it warranted taking 2 years to repeal something and to replace it with legislation that is purely ideologically driven by that side of the House. Now, if they hadn't taken all that time to replace those two bills, they wouldn't have needed a transition bill, which is what we are debating under all stages urgency in this House today. And what is the problem with all stages urgency? Firstly, the lack of analysis. It is just bad lawmaking, and it is becoming a trend of this government to push through legislation. So members opposite heckle, Labour did it too. Not as much as this government is doing. And secondly, you do it when there's an absolute need to do it. That is why urgency is allowed in this House, not to push through things because a government is shambolic and couldn't get their act in order, which is what we're seeing now. So it's bad lawmaking to keep pushing through bills that circumvent proper scrutiny and don't allow public consultation or public input here. And it's clearly stated in the departmental disclosure statement, once we got our hands on that, it says quite clearly here that there is no regulatory impact analysis because the urgency with which this legislation was prepared did not allow time for a RIS to be developed. There's also, under the section around the extent of impact analysis that is available, it clearly states here that several thousand consents have recently expired or are likely to expire next year based on the limited data available. That the Minister did lay out during the committee stage, that information is just not available apparently. But when it goes on to say that the analysis around the size of the potential costs and benefits of this legislation, no analysis around that. And again, it says here quite clearly that it's because of the urgent timeframes for preparing this legislation that have constrained the ability to undertake a broader analysis of the magnitude of costs and benefits with regard to this piece of legislation. I want to also lay out comments that have been made, Mr. Speaker, by environmental NGOs, most notably Forest and Bird, given that all of their voices were shut out of this process because there was no select committee stage to this, not even a short one, which the government could have done. Their concerns are around the blanket consent extensions that this bill provides for. And it's predicated on a few different things. One, of course, the environmental risk that it could pose. So when consents are extended without proper environmental assessments, it could pose a serious risk to biodiversity, to marine biodiversity, to water quality and taonga species. The other thing that it does is that it circumvents community and iwi or hapu input as well. Blanket extensions without thorough reconsenting or local review will bypass meaningful public input into this, and that undermines our democratic rights as a whole. Finally, what it also does, when you don't have a review process, you lock in outdated conditions as well. Things move on. You know, things change. This government is indeed stuck in time because science advances and progresses. Environmental conditions change. Climate impacts also mean that there will be potentially an impact on the environment. And if you have a review process for these resource consents baked in, it allows you to take those changes into account and then decide whether a consent should be reviewed or not. Forest and Bird also laid out some options for this government, which I was hoping to traverse in the committee stage, but unfortunately didn't get a call. And so I'll lay them out here. What this government could have chosen to do is to apply a risk-based review when it comes to consents. They could have chosen to enable low-risk consents to be progressed very quickly. They could have even allowed for higher-risk consents to be accelerated, but to bake in a review process with an allowance for community input there as well. They could have chosen to provide shorter extensions. A 6-year extension seems incredibly long. Given new consents can be issued from mid-2026, they could have actually picked a shorter time frame. And basically what the Minister said during committee stage was, oh, well, you know, we kind of had to pick a time frame and that's it. They could have also ensured that treaty obligations were met. Instead of just informing treaty partners, they could have consulted with treaty partners and not therefore potentially breached their treaty obligations. So, Mr. Speaker, there are a number of things that this government could have done better, but unfortunately they don't seem to be able to get their matters in hand. They could have foreseen that this was coming. They could have just stuck with the two bills that Labour worked on. That was actually essentially where they're getting to as well, because we did recognise the need for faster consents. However, we on this side of the House also prioritise protecting the environment. This government doesn't seem to feel the need to do that. We've seen numerous examples of how they continue to wage a war on the environment. This seems to be the next step. They've framed it as something that is transitional, something that is really nothing to see here, but they could have used this opportunity to do things better, and they chose not to, Madam Speaker, Mr. Speaker. And for all of those reasons that I've laid out, we do not support this bill.
Just point of order, Mr. Speaker.
Catherine,
point of order.
Aotearoa Williams.
Thank you very much, Mr. Speaker. I just want to draw your attention to the comment of Ryan Hamilton. He said during the speech of the conservation spokesperson of the Labour Party that she was not here. His exact quote was, "Because you weren't here." That is untrue and misleading. The reason why she didn't get a call was because the person in the chair at the time took a closure motion, and I'd like him to apologise.
Sorry, could you run that by me again?
No problem.
Yeah.
Mr. Speaker, it's both prohibited under the standing orders to comment on whether someone is in the House or not, and to say something which is untrue, whether that's in a speech or in a heckle. During the speech of my colleague, the Honourable Priyanka Radhakrishnan, Ryan Hamilton called out, "Because you weren't here," in response to her comment, "I didn't get a call in the committee stage, and so I will lay my argument out here." That is untrue, and it is unbecoming of a parliamentarian to comment in that way, and I'm asking you to ask him to withdraw and apologise.
Right, Mr. Hamilton, that is actually correct. So I won't ask you to withdraw and apologise because I think it's. I'll put that as a warning broadly that we don't comment on people not being in the House. But I don't think it reaches the threshold of withdraw and apologise. So,
Speaker.
Catherine Wedd.
Look, I'd like to give the opposition a little wake-up call. When you run a business, you need certainty. When you export apples to the world, when you export red meat to the world, you need certainty. And this bill is about giving certainty to those consent holders, to those business owners, so they can create jobs and so they can grow our economy. I commend this bill to the House.
Speaker. 5 minute split call, the Honourable Damien O'Connor.
Mr. Speaker, I'd suggest to that previous Speaker that she wakes up and comes into the real world. There's no certainty. There's not much certainty, and those people who will survive will be the ones who adapt to the changing circumstances internationally. Mr. Speaker, this is a desperate bill rushed through the House under urgency, and I'd suggest will be shown in history to be faulty. That's what usually happens. Mr. Speaker, what we have here is rhetoric overtaking reality. We have a piece of legislation being passed through the House to deal with about 2,500 to 7,000. No one knows because there was no regulatory impact statement done. No idea of what is the issue here at stake. 2,500 to 7,000, possibly, of 200,000 consents being managed by councils across the nation. This Parliament often passes legislation to deal with a very small minority of consent holders or people who break the law. This is the case now. But be careful what you ask for. The Resource Management Act was an act passed by the national government. It's been amended, it's been chopped and changed, mainly added to, and all would agree that it's not perfect. But the rhetoric that we have from the people in the House here, blowtorch to red and green tape, turning it on its head. This is what we hear from the coalition partners. Well, go to the World Bank and ask, what is the reality for New Zealand businesses in this country? What are the hurdles to operating, the so-called certainty that the previous speaker referred to? Well, actually, we've been judged number one year after year to operate business internationally. It's easier in this country than just about every other country in the world. Now, can I say that of course some of the regulations are not perfect and we should continue to improve them. But if you get into the rhetoric that we hear from the other side of the House, they're going to throw it all out. We are already a laughing stock internationally for turning our back on our international obligations around climate change and around biodiversity. This will further add to the declining reputation that our ancestors have built up. Mr. Speaker, the vast majority, as I said before, of regulation and legislation that we pass here is for the minority of people. Deregulation is a rhetoric that we've heard from that side of the House time and time again. They, in government, deregulated the building industry. We ended up with leaky homes. They, in government, deregulated health and safety. We ended up with Pike River and too many people killed at work. Mr. Speaker, they think they're going to deregulate the resource management process. I'll tell you what's going to happen. I'll tell you what's going to happen is that we will have a trail of lawyers up and down this country working out whose property rights are paramount, whose property rights are more important, when one neighbour versus the other, when the council versus the private property owner. Oh, they're asking, how is this relevant to the bill? What this bill is rolling over consents on the basis that it will offer certainty. You're kidding yourselves. You are absolutely kidding yourselves. This will not offer certainty at all. What is certain is that we all collectively have some challenges moving forward. And indeed, unless we address those, the rhetoric coming from that side of the House will give people false hope that they can get on and do what they like without any regard for environmental impact or the neighbour's property rights, because your individual rights as a property owner will be paramount. That's what we have heard from speakers on that side of the House time and time again. Let's be honest, as a parliament, let's say that the original Resource Management Act passed by the National Party, amended many times and now under new proposals, is designed to balance property rights versus environmental responsibility. We in Labor support that approach, but the idea that property rights will roll right through environmental responsibility is both ridiculous, it will undermine our international reputation and should not be supported.
I'm Grant McCullum.
The previous speaker talked about reality. Well, I'd like to give the opposition a lesson in reality. And the reality is simply this. I wish to commend the family, the Clark family, David and Jane, for having been brave enough to stand up and highlight the challenges that the previous regime was delivering for them, costing thousands of dollars and creating huge uncertainty for their family. And for that reason, I commend this bill to the House.
Aotearoa Williams.
Mr. Speaker, thank you for the opportunity to talk in this final reading of the Resource Management Duration Consents Amendment Bill, a bill that was introduced yesterday to the House, and here we are. It will soon be law in mere minutes. That is the way our legislature has been designed. Many people, much smarter than me, have commented on it, but it does seem relevant to reflect on it at this point in the year, when we're at the end of a year where the government has used urgency over and over again. It is less common for all stages urgency to progress like this, and in a bill which itself removes public participation rights. So there is both the removal of public participation rights at the primary legislative stage, and then the ability of anyone who wants to comment on the resource consents extensions is also curtailed. There's some poetry in that, Mr. Speaker. But let me turn to this bill and what it does, because it was actually really helpful, and I want to thank the Minister for his engagement in a committee stage that did bring much of that to light. When the opposition finds on the table the only information that is provided to us in a regulatory impact statement that is 2 pages long and generally answers all questions with a simple no. We are reliant on the Minister to talk through some of the policy choices that he has made and his intentions behind those choices. None of those have been echoed in the speeches by government members in the first, second or third reading. And so it's useful for us to continue to record them here. If the policy intention of the Minister is to be taken at face value, it's about getting the balance right. It's not about continuing consents that have existed just for 2 years, because that is the fix in and of itself. This idea that 2-year extensions on consent has no impact isn't in fact what the Minister was contending at all. That a 2-year extension is a valuable property right bestowed on these people simply because they have stacked up first is something that he was trying to achieve. But it's important that we know what we're doing here, because that has an impact financially on the neighbours, on the people down the street, on the people downriver, on the people in a community if it is an air discharge. I want to say to the electorate MPs on the other side who are frustrated with opposition MPs raising these questions and pointing these things out. If any of you are electorate MPs who have been involved with communities who have brought to you petitions about the local dump discharging its odours next to the school, if any of you have been an electorate MP who has talked to a business owner who is worried about the business that is opening up down the street with a water take or a discharge, this is that. This is about those business owners, those neighbours, those people who come to you and they say genuinely, I'm trying to do absolutely everything right under the law. And I'm really worried about the person down the road who I think is taking too much, is in the 1980s was granted these rights and it doesn't fit with the character of the neighbourhood anymore. I want to live here undisturbed. I want my kids to be able to go to school down the road without air pollution in the community, because now this community has grown and there are more people here. This is that, right? We know that this is an extension of those rights for 2 years without any of those ability. That mum who sat in your office and raised with you this issue of the kids going to school next to the air discharge at the plant, which was built in the 1970s, this is about her. And this is the legislative answer to her, which says you have no say. You know that, right? And when she comes to you and you say as her electorate MP, I would love to help you. This is a legitimate concern. Good on you for going around your neighbours and getting a petition of 20 people. This is engaging with democracy. Good on you. As your electorate MP, that is my role. I will take this to Parliament. I don't necessarily agree with you, but I will raise it with ministers. This is that. This is no to that mum. This is no to those community groups that want to go to council and have a say on the water takes. This is no to the business owner downstream from those people who have water takes that were granted in the 1980s and are no longer appropriate because the environmental science has moved on and we know more about their uses. This bill does that, and there are trade-offs to be made here. But shouting down concerns that are being raised here about public participation is saying no to those people. And the choice that has been made here from a policy perspective is about whether the balance is right. And that comes down to what resource consents are for. And the resource consents that have a time on them are not land consents. We're not talking about the owners of most blocks of land, because those consents don't end. The consents that do end, Andy Foster, are water takes, they're irrigation takes, they're air discharges. They're the ones which do have a community impact. And the reason they have a timing on them is because people want to have a say on those. So these are the ones we are talking about. And when we're talking about the extensions for farmers, we are talking about the ones where there is legitimate community concerns, where we want to engage in a community dialogue about those. So there is a trade-off to be made here. And it was useful in the committee stage to tease out some of these issues. Issues like when you make planning rules changes in Auckland, you have a complicated web of different planning changes. They're called PC number. And in the case that occurred in November last year, Council adopted some new rules that were essentially given effect by planning changes that we made in this House, and all of a sudden, developers who were wanting to build 3-storey houses because they were relying on the MDRS, the medium density rules, couldn't build those anymore. We haven't solved that problem for them, and this bill could have done that. I put that to the Minister. He is working through that, but this is another missed opportunity and a reason why a rushed legislative process where people can't come along and have their say, they can't come to their local MP and say, hey, I'm a mum and dad developer because I've had this land for 10 years. It's now the right time in the market for me. I can get a builder cheaply. Husband can do some of it himself. We're really excited to build this 3-bedroom townhouse. No, it's this bill, Ryan Hamilton. Perhaps you could have been listening in the committee stage, which you were clearly in the entire time. The issue here is that when those developers weren't able to develop their land, this is not solving it for them, and this is not solving it for everyone who has issues with the timing involved in introducing this kind of reform. It's only dealing with those sorts of consents like water discharges, like air issues that have public participation in them, and it's just a blanket extension which creates an extended property right with no protections for community. In the least to say that this bill also absolutely limits the right of Māori participation in the extension of these, that we have moved on so far from the 1980s, and that should be progress we can all be proud of as New Zealanders, where the ability of iwi and hapu to make their views heard about the use of water, about the use of air, has changed. And that is generally, I think, everyone in this House would agree that that is a good thing. They are not able to do that. In some cases, they have been waiting 25 years, 30 years, 35 years to be able to have their say about these water takes, which were granted many years ago, before they were settled, before they had an office, before they were able to collectivise and have a say in the environmental planning regime. And they will not be able to do that now, not just for 2 years, but effectively until 2031. And that was an issue that we played out at the committee stage, we got to the bottom of. It was useful to really understand what this government is doing here, that those rights will be curtailed, that there has not been consultation with iwi, with hapu, with Māori affected landowners at all before the introduction of this bill. And one can only assume that the quick introduction, the lack of consultation with the opposition, and the way that now iwi, it is said, will be informed of this rather than consulted, is because the government feared the litigation risk because of this. And why is there litigation risk? It's because iwi want to have a say. They want to be at the table when it comes to matters of water and air, because they want to be able to be alongside government and local government and make those decisions as kaitiaki of their whenua. And that's something we should be all able to agree with, but that is not what's happening here. Finally, Mr. Speaker, I want to reflect on the difference in making a decision like this under all stages urgency and having it been through committee. We won't know how this affects people or who it affects or how many it affects until this law takes effect, but we all should. All of us who are electorate MPs, who have water takes in our area, who have pollution discharges into our air, when you look up and you're an Auckland MP and you see the smoke in the columns going up, you should know that that has been extended, and you should find out what your community thinks, because that's your job and that's the decision we have made today.
I'll just say touche, Ms Williams. Ryan Hamilton.
Oh, thank you, Mr. Speaker. Look, I won't take too long. We were criticised for being rushed with this process and taking 2 years to build the RMA. And in that process, we've created this hybrid bill to, I guess, grandfather or piggyback or support those that are caught in between the legislation process, to carry them over and give them some security. We've heard all the scaremongering from the other side about treaty and rushed and all this stuff, but Mr. Speaker, this is pragmatic. New Zealand is watching, and I'm proud to be part of this once-in-a-generational change. I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā pōti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Pōti whakahe.
Taku Te Wheres.
Kotahi te pōti whakahe.
Mariamino Kapakingi.
1 vote opposed.
The ayes are 68, the noes are 55. The question is agreed.
Resource Management Duration of Consents Amendment Bill, third reading.
I move that the Emergency Management Bill...
The Honourable Mark Mitchell.
Thank you, Mr Speaker. I move that the Emergency Management Bill be now read a first time. I nominate the Governance and Administration Committee to consider the bill.
Was there a legislative statement there, Mr Mitchell?
The bill will replace the Civil Defence...
Mr Mitchell, was there a legislative statement? You were...
I present the legislative statement, Mr Speaker.
That legislative statement is published under the authority of the House and can be found on the Parliament website. Honourable Mark Mitchell.
This bill will replace the Civil Defence Emergency Management Act 2002 and make a number of changes which respond to the government inquiry into the response...
You're now required to finish moving the bill. Sorry, just to...
I move that the Emergency Management Bill be now read a first time. I nominate the Governance and Administration Committee to consider the bill.
Thank you.
The bill will replace the Civil Defence Emergency Management Act 2002 with a number of changes which respond to the government inquiry into the response to the North Island severe weather events of early 2023. Mr Speaker, I want to acknowledge the work done by colleagues across Parliament who also recognise the need to strengthen our emergency management system. There are two areas, Mr Speaker, that I feel are really important for us as a Parliament to work together on. One is national security and the other is emergency management. And firstly, I want to acknowledge the outstanding NEMA team, right from the leadership through to our policy team, who have worked very long hours, burning the midnight oil to work on this bill and bring an outstanding bill to the House, right through to our people that deploy, that provide advice, that work on education and man our information centre 24 hours a day, keeping us updated with information as it unfolds around our country. We are a country that will continue to be hit with weather events. I want to acknowledge the mayors, the chief executives and our civil defence controllers and all the stakeholders who have been engaged with us on the development of this bill. I want to acknowledge them and their hard work and their engagement. I want to acknowledge Camilla Bellich and Francisco Hernandez for the work that they have done with us on this bill in a very bipartisan way. Camilla, I want to make a special mention to you. Not only has she worked very closely with me on this bill, she is on the ground at several of the events that I've been to that have been local states of emergency, and I appreciate your engagement because I think that in terms of emergency management we all need to be working together on that, and I know that's appreciated when you're on the ground also. I want to acknowledge the previous ministers, Kieran McAnulty, who provided me with a seamless takeover when I took over from him. Kerry Allen, who continues to work in emergency management through the Iwi Leaders Forum and has worked very well with us, and Marama Royal, I want to acknowledge them. Penny Henry is the previous minister. Chris Farfoy, who I've done a lot of work with, who now has a leadership role with our insurance agents companies and has done a lot of work with me. Nathan Guy, Jerry Brownlee, can I acknowledge Jerry Brownlee, who has given me a lot of extremely useful advice, especially around recovery. I don't know if there's another minister that has been in this House in our recent history that has had to deal and do the heavy lifting around recovery, and I want to thank him and acknowledge his outstanding guidance advice for me in this role. And finally, I want to acknowledge Nikki Kay, and I'll finish there, but I wanted to mention Nikki Kay because I think the whole House would agree that you would not have found a more passionate Minister of Civil Defence than Nikki Kay, and the astounding amount of work that she got through in the 3 years that she was Minister. Mr Speaker, the previous Emergency Management Bill proposed a range of sensible changes that we have taken forward, but it predated the inquiry's final report, so it didn't go far enough to address lessons from Cyclone Gabriel and the Auckland anniversary floods. The frequency, complexity and consequences of recent emergencies have highlighted the importance of updating the legislation to improve how we manage risks, prepare for, respond to and recover from emergencies, and empower and support communities. New Zealand's approach to emergency management is based on three key principles. First, we need to pay attention to all hazards, natural and man-made. Second, we need an end-to-end approach to managing the risks from those hazards. That means taking action across the 4 Rs: risk reduction, readiness, response and recovery. Third, all parts of society have a role to play in emergency management. Risks should be managed by those who are best placed to manage them. This was an intent of the CDM Act, and this bill follows the same philosophy, but the inquiry and other reviews have made it clear that New Zealand has not achieved what Parliament envisaged when the Act was passed in 2002. The inquiry, as well as submissions on the previous bill, informed our reform objectives and proposals, which were publicly consulted on earlier this year. That consultation has led to over 20 substantive changes being made through this bill, in addition to a general overhaul to modernise the Act. The majority of submitters agreed to our reform objectives, which are to strengthen the role of the communities in iwi, Māori and emergency management, provide for clear responsibilities and accountabilities at the national, regional and local levels, enable a higher minimum standard of emergency management, minimise disruption to essential services, and ensure agencies have the tools to do their jobs effectively when an emergency happens. I'd like to touch on some of the most significant changes the bill will make to deliver on those objectives and make a real difference on the ground. To strengthen the role of communications and iwi, Māori and emergency management, the bill provides membership roles for iwi, Māori, rural communities and the wider community on coordinating executive groups. These groups are currently made up of local authority chief executives and senior representatives from emergency services in each area. They are responsible for advising the local political level of emergency management. Having a seat at the table will give iwi, Māori, rural communities and the wider community a direct role in informing what their Emergency Management Committee does to reduce risk, get ready for emergencies and respond and recover when they happen. The bill also requires engagement with iwi, Māori and the wider community, particularly those who may be disproportionately affected by emergencies, whether they have existing vulnerabilities or different needs that don't suit a one-size-fits-all approach. Emergency Management Committees and the Director-General of Emergency Management will be required to identify these groups, such as disabled people, seniors and our culturally and linguistically diverse communities, and engage with their representatives when developing regional and national emergency management plans. The bill also provides for more clarity about roles and responsibilities at the national, regional and local levels of emergency management to ensure faster decisions are made by the right people. The need for role clarity has come up in the inquiry and other reviews, and I've seen it firsthand at emergency events over the past 2 years. It is absolutely critical that responsibilities and accountabilities are clear. Any confusion about who is making decisions causes unacceptable delays during a response. Local government has key roles in emergency management. The vast majority of emergencies play out at a local level, and other legislation gives local authorities many of the levers to manage hazard risks. Councils know their own communities best when an emergency cuts communication and knocks roads out of action. Local resources may be all that's available to respond for the first few hours. But the bill retains committees of the councils in each region. Each exists to provide economies of scale and enable regional coordination of emergency management. However, it puts more emphasis on councils' individuals' responsibilities by creating specific roles for regional emergency committees and their local authority members, making mayors primarily responsible for declaring states of local emergency and recovery transition periods within their own districts, and requiring every territorial authority to have a district controller and district recovery manager with a clear line of accountability to the council's chief executive. Given territorial authority chief executives an explicit mandate to coordinate resources provided by other agencies in the lead up to an emergency and over the long-term recovery is essential. The bill also addresses current ambiguity around who is in charge during an emergency by formalising and clarifying the concept of lead agencies as the central government agencies responsible for responding to emergencies caused by specific hazards. Lead agencies will be required to keep the Director-General of Emergency Management informed of situations where there is or may be an imminent threat to an emergency. In turn, the bill places a duty on the Director-General to inform the Minister about such situations. Timely and reliable information is a key part to determining whether a situation may meet the threshold for a response under the bill and provides a better chance of addressing the situation before it escalates. Regional emergency management plans are key instruments for driving action across the 4 Rs at the local government level. They identify the hazards of risk to be managed by each emergency management committee and set out the policies, projects and other necessary measures to manage them. These measures could include things like identifying bylaw changes, setting requirements on each of the committee's councils to build their response capability, or agreeing to progress joint risk reduction initiatives. Mr. Speaker, I wanted to finish my speech today in an acknowledgement to an outstanding NEMA manager in the Christchurch area, Rochelle Faimalo. Rochelle passed away peacefully on the 13th of August this year, wife to Joe, mother to Azure, Zion, Quest and stepmum to Georgia. She quite simply she typified the quality of the people, the qualities that our emergency management people right across the country bring to that role. I met her during the Port Hill fires, where she played a critical leadership role. This will be the first Christmas that their kids don't have their mum. She was 40 years old. She was a much loved member of the NEMA team, and she was very passionate about this bill coming to the House, which she was briefing mayors on right up till June. So I wanted to acknowledge her, and I wanted to let the family know that we're thinking of them during the Christmas break. Thank you.
The question is that the motion be agreed to.
Mr. Speaker.
Camilla Bellich.
Thank you, Mr. Speaker. And I just want to acknowledge the contribution of the Minister and also echo our condolences to Rochelle's family. I know that the work on the Port Hills fire was really exceptional, and as the Minister will know, or anyone who's worked in this area, the people who are involved in emergency management around New Zealand are really exceptional people. Often it's a career that they end up being in for most of their lives, and it's not because of anything that they personally gain from it. It's from really a feeling of service and contribution to New Zealand, and so we're very grateful to them, and it's always sad to hear of one of our colleagues who has departed. So I want to acknowledge that family. Also want to acknowledge and reiterate the acknowledgement that the Minister made of people who have been involved in this bill. This bill is something that has gone over a series of governments, and that is the nature of emergency management. Emergency management is something that is exceptionally important to New Zealand and exceptionally important to our communities, and we never know who's going to be in government when an emergency strikes, and all that we can hope on either side of the House is that we can do everything that we can and that we have the best processes in place. And so this is something that is a genuine area, I think, of bipartisanship, and something that we on the side of the House and in the Labour Party take very seriously and have done when we've been lucky enough to hold those ministerial portfolios as well. And I know many of those previous ministers hold a very lot of interest still in this portfolio because of the importance that it has to New Zealand and to their communities. So I want to acknowledge the Minister for your work here as well, and also your team, especially Bailey in your office, who works very hard to make sure that we're all aware across the House of emergencies when they happen to. And I think that kind of approach is really what this bill is meant to legislate for. It's much more of a all of government rather than little sectors working on their own. So this is an important bill, and it's kind of the antithesis really to the previous bill we were discussing, Mr. Speaker. This bill has really had its genesis in changes that were seen to be needed in the 2002 Act. There's a consensus, I think, from everyone that piece of legislation is no longer fit for purpose,
anymore in New Zealand, and various governments have, and there's been so many reviews, and there've been various governments have looked into trying to amend this. And I suppose the issue that we have is we keep having emergencies, and we keep realising that there are issues in our system. And I think it's important to acknowledge that we will never have a perfect emergency management system, and we will never be able to do everything. But that doesn't mean that we shouldn't do everything that we can, and that we shouldn't learn every lesson that we can in order to be better prepared. So when we were in government, Labour was in government, we did introduce a bill, and we're happy to see that a lot of the sensible, pragmatic suggestions that were in that bill have been carried through into this new piece of legislation as well. And the big thing that happened in between that introduction of that bill was the North Island weather events. A significant event for New Zealand. I want to acknowledge the 15 people who lost their lives in those very sad events, including children. I think couldn't be more serious that we get this system right, and certainly we will not stand in the way of making sure that these changes are implemented as soon as they can be, and so it's timely to see this introduced. We had a slightly different approach, it's fair to say, at Select Committee when we saw the report into the government inquiry into the North Island weather events. We thought maybe we could amend the existing bill and that would be faster. The government took a different view. That's their call. That was not something we agreed with at the time, but I think, as you could have heard through the Minister's reflections, we tried to work very constructively with that decision. And as chair of the committee where this bill will go, definitely will be taking the scrutiny of this bill very seriously and making sure that we put forward the best possible bill to the House in order for this to be enacted, hopefully as soon as possible. I don't think we will ever have a perfect piece of legislation, but we certainly must implement the lessons that we learnt from that government inquiry. That government inquiry included at least six separate reviews and also several other studies into what was happening in our emergency management system. So it's really imperative now that we do implement this. This has been well thought through. We're talking about regulatory impact statements. This is the regulatory impact statement on this bill. Extremely long, extremely thorough, extremely well thought through. This has had a previous Select Committee process on the last bill. It's had a initial consultation process from when the roadmap was set out by this government. It's had significant amounts of submissions from the public already, and so and then I understand it will go through a full Select Committee process as well. So this is something that the full democratic parliamentary process and all of the tools we have in relation to looking at the quality of our legislation have been utilised, and I want to commend the government for that. And it really should mean that there hopefully won't be any barriers to this bill being passed and being legislated for. I wanted to mention an important area which I think is reflected still in this bill, but is a bit of a difference from the previous bill brought in under the Labour government, and that's the role of iwi Māori in emergency management. We have seen it again and again, and one of the key findings from the government inquiry into the North Island weather events was that every time there is an emergency situation in New Zealand, whether they're asked to or not, whether they're at the table or not, iwi Māori marae step up in emergency situations. They take care of the people, they house people, they feed people. They have been taking on this role for generations, and whatever the legislation says, that's not going to change the manaakitanga and emergencies that iwi Māori have. And my colleague Kushla Tangiru Manuel took me up to Tairāwhiti, and I met some of those very people who took on that role during Cyclone Gabriel. So it's really important that that is acknowledged. The current legislation does not acknowledge that at all. This legislation does have a seat for iwi Māori at the Committee on Emergency Management Group, I think, the KEG group. That is something that we very much support, and I should note that it's not just one seat, it's one or more seats, so it depends on the different area as to whether more people should be involved. And there are also another couple of areas where iwi Māori can also participate and through being consulted as well. We had suggested a National Māori Emergency Management Advisory Group that hasn't been taken forward in this piece of legislation. From our perspective, that's regretful, but at the same time we see that there has been a concerted effort to improve the status quo, which is nothing at all at the moment by the government and the minister, and want to acknowledge that, and also the significant treaty analysis that's been involved in the regulatory impact statement, and the intention of recognising what was in the government's report into the North Island weather events, and making sure that there is recognition for that key role that iwi Māori play in our emergencies in New Zealand, and the fact that they have a right to have a seat at the table when decisions are made. So this bill is an improvement, and we do support that, so thank you to the Minister for taking that forward. There are other things in this bill which are significant changes. There are changes to ministerial powers, there are changes in relation to information sharing, and I should acknowledge as well, one of the benefits, although we didn't support the bill being discharged at the time, has been that the issues that we've seen in very recent events have been incorporated into this bill, and so I think that is a benefit. So one of those things is information sharing. There have been issues in recent events where information hasn't been shared in the way that it could most usefully be shared in order to assist the emergency management response. So I think that is a very good change as well. There's also, as the Minister said, changes around decision making. We know that it's really clear that there should be a really clear decision making process in emergencies. That hasn't been as clear as it should be under current legislation. I think this legislation will improve that as well. So that is something that we definitely support. The situation in emergency management in New Zealand is that we need to take seriously the fact that, as the Minister often says and is recorded in the government's report, which this bill is really based on, is the fact that we do have the second most at-risk country in the world, and we are one of the developed countries with the most at-risk profile in the world. That means that we should be, in theory, the best at the world at emergency management, and I'm sure that is a desire shared across the House, that we need to do whatever it takes to do everything we absolutely can to ensure that emergencies, when they do occur, are run with the best available information, with the best systems. We know we have the best people, so it's just about utilising that collective information to do the things that we know will assist in the response. So I thank the House and this government and previous governments for the work on this bill, and I commend it to the House.
Just before I take the next call, just to acknowledge we did have an error with the clocks. First reading speeches after the Minister speaks are 5-minute calls. So from now on there will be 5-minute calls. I'll take the next call.
Thank you.
Francisca Hernandez.
Thank you, Mr. Speaker. I rise to speak in support of this bill, and I wanted to thank the Minister for his leadership and engagement on this. We know that in this portfolio you've been willing to make some hard but not so popular calls, so we do think that is a mark of leadership. And we also wanted to echo the condolences you've expressed to the families of Rochelle, and the thanks that you've expressed to the emergency management workers all around the country. The Greens are always uncomfortable supporting any legislation under urgency, but I've been assured by the Minister that it will go through the full select committee process, so that's assured us. And I also appreciate my colleagues across the House and the cross-party nature of the way that we engage in emergency management. I always appreciate everyone's passion and engagement at the Government's Governance and Administration Committee, ably chaired by Camilla Bellich, when the topic of emergency management comes through. Everyone's passion for emergency management and a genuine desire to serve the country really comes through in those discussions. I mean, I think sometimes, Mr. Speaker, when we scream at each other across the chamber like animals, we lose sight of the fact that, everyone here is like intelligent adults that are doing their best to serve the country, and that does come through in those select committee discussions. And look, it does show what we can do when we work in a cross-party way. We can make good law, and we can go through full select committee process. And while legislation of this is really welcome, we do need to actually address some of the drivers of the emergency management events that are increasingly occurring. Since 2023, New Zealand has been, either nationally or locally, in some state of emergency for 224 days. Every single one of these days has been due to a fire, coastal hazard, or severe weather or flooding. Most of these events, Mr. Speaker, are exacerbated by the impacts of climate change. Every single greenhouse gas we emit contributes to heating up our atmosphere, and every single fraction of a degree exacerbates and amplifies the impacts. Now, in the same urgency block that we are passing this needed and necessary legislation with cross-party support, this government has also introduced a bill that would gut the Climate Change Response Act by weakening our emissions reduction targets, watering down the Independent Climate Change Commission, and gutting our emissions trading scheme. It's a little bit like increasing the funding to the fire service, something that's urgent and necessary, by the way. At the same time, you're handing out fire starters. So, look, we do support this bill. It is a good and necessary bill, and we support in particular the increased coordination between local and central government that this bill enables, the requirements for lifeline services to contribute to emergency management plans, the increased protection for animals in emergency management situations, the increased oversight for emergency management powers, and the increased role in increasing the role at the table for iwi and Māori. But there are things that we think that this bill could go further on, and these are the things that we will push during the Select Committee stage. And we do know, as my colleague Camilla Bellich has said, that the original emergency management bill that was introduced by the then Labour government had stronger provisions for working with iwi Māori. We also want to ensure that disabled people are included in the emergency management planning, and we will continue to push for greater integration with climate change adaptation frameworks, because the risk reduction aspect is really complemented by efforts to ensure that they're being aligned with climate adaptation efforts. And outside of the legislative process, we will continue to fight for what we always have fought for: fair funding for workers and the emergency management frontline, at the climate emergency management frontline, like firefighters, so that they can have fair pay and conditions and safe equipment. So I wanted to close by thanking the emergency management workers, not only at NEMA, not only at the people working across the different councils, but also the people at the the front line at the emergency management response, whether they be police, whether they be ambulance workers, nurses, people who are really dealing with the actual frontline impacts of the emergency management events. And I really wanted to thank in particular to the firefighters who came to talk to us at Parliament forecourt last night. We do stand with you and all the other emergency management workers around this country. And I hope that you can see with the cross-party support that this bill is getting, that we do support emergency management across the House in this country. Kia ora.
Mr Speaker.
Laura McClure.
Thank you, Mr Speaker. I rise in support of this piece of legislation. I also want to acknowledge the Minister and his work, and the opposition members for their work in this this reform that we greatly need. I also want to acknowledge Rochelle and her family, being from Christchurch. I did not know her personally, but I do have quite a few friends and family that had worked with her. Some of you may know or may not know that before I became an MP, I actually worked in this space for the last 15 to 20 years. I'd been doing emergency response planning, mostly in the evacuation side of things, but I'd been working quite a lot out there with our communities and with our councils, with our iwi, around improving the systems that we have. And time after, we would often hear that when disaster strikes, there was a lot of confusion, a lot of bureaucracy, a lot of red tape around what could and could not be done. What I'm really happy to see is that this is enabling more of a community-led approach. And I think that's a really important thing, because we all know that communities know the person to get on the phone and call up when they need a generator. We know that central government rolling in to do that job is not going to have the same effect. So I think that this bill's a really great start, and it's heading in the right direction to empower those communities. We also know that failure to prepare for a disaster means that we prepare to fail ourselves. And that is something that I've always said to people, and it's highly important that we actually go into the preparation a lot more. And I hope to see that these established groups really do get into the preparation and actually go through some of the scenarios. I know that the former member, the member across the other side of the House, talked about we could have any system and it would never be perfect, and that is actually true, because you can never prepare for some things. But what you can do is you can make sure that people know their roles and they know who to call and they know where to go. And that has to be led from the community. I do have concerns with the bill that the community part of it doesn't include our NGOs, our other community organisations and our other groups that are actually on the ground as well. And I think that we need to consider that, and I really look to those, particularly the councils that are going to be setting up these groups, to think about the other people that are often involved in a disaster and also that recovery phase as well, because we want to decentralise this process as much as possible to empower those communities to do the right things. We also have a bit of a concern about the Mataranga Māori and the tikanga into the committees. I think while we definitely need local voices and local iwi, we have to have that. It's really important. But we don't want, somebody coming in from central government just saying, oh, I know the tikanga, that this is how it's going to be. So I really want to make sure that when the select committee goes through this, that they actually consider that these are locals, these are people from the marae that are involved, because that's how we're going to drive the best outcomes. So thank you, Mr. Speaker. I commend this bill to the House, and I'd like to see where it goes in the future.
Andy Foster. Thank you, Mr. Speaker. Look, I rise on behalf of New Zealand First and also as a member of the Governance and Administration Select Committee. Looking forward to considering this bill later on. Just want to start by saying thank you to Minister Mark Mitchell, both for the work that's gone into this, but also for the way in which you've engaged with the Select Committee every time you've come along. It's been a very open conversation, and I think that's great. So really appreciate that. Mr. Speaker, it was Sir Humphrey Appleby who said that civil defence is a joke. Everyone knows that civil defence is a joke. I don't think he'd have given that advice if he'd been living in New Zealand. And I look at what the information which many of you will have seen that NEMA has given us. We have been in New Zealand since 2016. There have been 87 local and 2 national states of emergencies declared. Total 559 days, at least at the time that this was published. That's equivalent to 1 day every week for that 10 years that somewhere in the country, or the whole country, was under a state of emergency. So it is a big deal in New Zealand. And looking forward, NEMA talk about the likelihood of serious and significant events. And you look at this and say, there are some certainties in life. There's death, there's taxes. And I'll tell you what, in New Zealand, there is emergency, because there will be some. I mean, even if you look at one particular one, which is the AF8 situation, next 50 years, 75% chance of that happening. That's not quite certain, but it's getting right up there. So being prepared, being able to respond to emergency is absolutely essential. This emergency management bill has been long awaited. It's been great to see a lot of engagement. If we did lots of engagement before all pieces of legislation, that'd be a really good thing, because there'd be much better legislation for it. And I'm sure that this will improve the legislation that we've got in front of us at the moment, the level of public input. It's important, Mr. Speaker, I think that this bill delivers all that we need in terms of emergency management. I don't know how hard it is to get a legislative slot, but I don't imagine it's easy. So this is the shot that we have to get emergency management right in this country. Mr. Speaker, the bill talks about 3 things: taking an end-to-end approach, come back to that in just a second, considering all hazards, and all parts of society playing a role. And we've had a lot already, the discussion about the importance of community, the importance of iwi being involved in emergency management and emergency response. We also talk, Mr. Speaker, about the 4 R's: reduction, readiness. We can't avoid risk, but we can consistently work to reduce that risk. There's also response and recovery. And the danger, I think, Mr. Speaker, in these things is we focus too much on the response and recovery and not necessarily enough on making sure that we don't have the problem in the first place. So 3 quick lessons that we've had with the engagement, particularly with you, Minister, and our engagement with NEMA. The first one of them is that we need to stop reinventing the wheel with every single different event. Every event that we have, it's who do we need to get involved in this event to try and respond to it. We've got to do better than that and be switched on right from the start. That's the kind of bureaucracy, I think, that we've just heard about from the previous speaker. Secondly, we've got to stop building dumb things in dumb places. And I just want to think about the Auckland situation where we've had to change the planning laws so that we didn't put 3,000 plus homes in a place which was subject to flooding. So we stopped building dumb things in dumb places, and you get a lot of support from that from the insurance industry and our Hazards Commission. But also the question is, what is the role of NEMA in saying stop building dumb things in dumb places, because I think that they should have a role in doing that. And the third one is adaptation. We've already heard a little bit about adaptation, but I just want to call out one particular thing. We were at a meeting in Hamilton not that long ago, middle of the year I think it was, and Shane Jones was talking to that meeting, talking about investment in the regions, and somebody stood up unprompted and said, look, thank you very much for the work that was done under the Provincial Growth Fund in protecting Taradale. And what he said is that the floodwaters under Cyclone Gabriel got within a few feet of the top of that flood bank. If they got over that flood bank, or that flood bank had not been there, just think of the loss of property, and worse, the loss of life that would have happened. So preparedness, really, really important. Mr. Speaker, just to finish off, there are a lot of aspects to emergency management, and at a recent visit to the West Coast, they're very anxious about emergency management. I mentioned the AF8 situation, the availability of Bailey bridges, fuel and equipment, how we manage events and tunnels. Visited the mines rescue, and they raised issues not only of those tunnels that they have there, but also of road and rail tunnels. So there's a lot that goes into preparing for emergencies and then to responding to them. Mr. Speaker, looking forward to Governance Administration hearing submissions and considering the bill, and I commend the bill to the House. Thank you.
Tēnā rā koe te pika o te rā, tēnā rā tātou e te whare. E tū ana te Pāti Māori ki te tautoko i tēnei pire, waihoki ki te mihi atu ki te minita, kia koe Mark me o mahi, me o kaimahi roto i tēnei o ngā pire, waihoki ki ngā kaimahi putanoa i te motu, kua rau o rātou ringa raupa ki tēnei momo mahi i roto i ngā take āhuatanga o te motu me ngā huarere o te wā. So Te Pāti Māori supports this bill, and I just want to extend our mihi to the Minister, Mark, and also the condolences to the whānau who have lost a great wahine, and also acknowledging all the kaimahi within the emergency response team throughout the country. I'm sorry. This bill implements parts of the government's response to the 2023 inquiry into North Island severe weather events, finding that the current emergency management system was not fit for purpose and lacks the capacity or capability to deal with the significant emergencies affecting many regions. Thank you very much. Many regions at once. The inquiry also underscored the fact that Aotearoa has not achieved the whole of society approach to emergency management that Parliament envisioned when the CDEM Act was passed in 2002. I was born that year. A point solely understood by marae throughout the country. Iwi and Māori communities may be offered seats on committees and involvement in emergency responses that they would have let out anyway, because iwi and Māori don't sit around waiting for somebody else during and after a disaster. Rather, iwi and Māori choose to lead together when no one else will and can. Iwi, hapu and marae often place themselves forward as bastions of protection and manakitanga to all communities affected. Tikanga steps forward where government legislation is inadequate. Iwi and hapu step forward where government agencies and authorities do not know where to look, who to speak to, or how to help. These acts of manakitanga and rangatiratanga rang true during the Christchurch earthquakes and later the Kaikoura earthquake. More recently, the profound role of iwi Māori was demonstrated further during the Edgecombe floods and the Whakaari White Island disaster and Cyclone Gabriel. E te pika, it was the late Dr. Ranginui Walker who said this: the marae is the focal point of Māori culture and communal activities, but the contemporary history lesson here is that the marae are often the focal point of emergency management and communal uplift. The marae is not only, as Dr. Ranginui puts, is a place to stand for Māori people, it is often a place of refuge and aroha for all people who enter its gates. And deeply held notions of mana and good faith towards all people who make up the diverse communities. Maraes are not businesses, and most don't don't have regular income and resources to support their functioning. So at times I must acknowledge the PGF fund that many marae have had across the country. And yet they are relied upon heavily by both governments and the public to provide support and relief despite the taxpayer-funded role and obligations of authorities. I might also just, while I've got the last minute, want to shed light on some of the young rangatahi Māori who have used their studies to contribute to their to taiao climate resilience and also their maraes. I want to acknowledge one person, Haukapua Nui Verko, who has used his PhD to future planning all maraes across the country and how we can better use our infrastructure of maraes because majority of our maraes are actually close to wetlands and are predominantly exposed to flooding. And that would be a great person to have on the future Māori Advisory Committee. Nō reira, tēnā rā tātou e te pika.
Tim Kosso.
Merry Christmas, Mr. Speaker. Our philosophy for civil defence, emergency management in New Zealand has always been one of everyone in the community has a role to play. A small nation, we rely on each other. And this bill formalises that, whether it's in bringing in iwi, rural communities, these groups that have people, they have manpower, they have infrastructure, not just marae, they have machinery. And I think that's a great thing. I commend the bill to the House.
Le maunga Lydia Sosene.
Well, thank you, Mr. Speaker. I rise to take a call on the emergency management bill. And in particular, I would like to acknowledge the Minister, but also my colleague, Camilla Balich, who is the Chair of the Governance Administration. And I'm really pleased that I'm a member of the Governance Administration because we will be scrutinising and looking at the bill when it gets to Select Committee. Mr. Speaker, I do want to just mention that Labor did have an emergency management bill. The bill had been, in our version, through extensive policy development and Select Committee process, and progress could have been faster. However, we are now at this point. I want to acknowledge, as Minister highlighted, a family who have lost their loved one. We want to pass on our condolences, but also too, Mr. Speaker, in terms of the weather events that have happened for quite a while, it is important to remember it wasn't just the people that we lost through those tragedies, but also all the communities that have been affected by these weather events. And so this bill represents a very important step for New Zealanders throughout Aotearoa in terms of strengthening and understanding the pivotal points that when you're designing a framework, it's important to understand the differences of a community, but also the strengths that can be represented through an updated emergency management system. Mr. Speaker, I have a personal story because in the Auckland anniversary events, we were in a car and the whole motorway got flooded. There was chaos. It was a Friday evening and people just did not know what to do. And in my local community in Mangere, it was absolutely chaos because the flood waters were rising on the roads and many families were affected. It was before 6 p.m. that evening. People were coming home, picking up children. It was just absolutely chaos. And in that specific Friday event, who we had just left Hoani Waititi Tangi at a marae, it was a scary time for many citizens who were going about a Friday evening and then bang, the torrential rains. It was a very scary time. If I reflect back at that time, my immediate thoughts is, what is our emergency management system? Cell phones were not going, the floodwaters were rising. It was a very scary time. And I was thinking about our elderly, our non-able-bodied community members. It was a very, very scary time. So I do want to acknowledge all the first responders. People were checking their phones. We were trying to reach family members. It is really important that citizens in our community understand the readiness and the response. So I want to acknowledge everyone that has been through. We have lost New Zealanders. We actually lost 15 New Zealanders through those events. And so through those difficult times, what are the lessons and who is responsible in providing specific leadership, either in a central government capacity or a local government capacity? When we're thinking about emergency management, one of the things, and Tulo, respectfully, we immediately think that everyone speaks English. We don't think about our matuas, we don't think about our citizens where English is their second or third or fourth language. And when we are interpreting, when we are designing frameworks, it is important that those who are contributing keep different nationalities and ethnicities in mind, but also the ages. Not everyone, not our citizens are all going to understand the instructions that come out either on your device or on paper, what is important. So I'll just move to the last points that I wanted to make. It's important that we reflect back on personal stories, but we get this right. I really appreciate the bipartisan and approach in terms of acknowledging those. And lastly, I want to focus on the role of iwi Māori. In every tragedy or circumstance that has happened, specifically in Mangere, specifically in South Auckland, iwi Māori have always been there. They don't come to or reflect on, we want this. They just say, here we are, this is what we need to do. I want to emphasise and focus the importance of their role in every or any planning committee in a community. I also want to make sure that the leadership and clarity for iwi Māori is understood in the framework. I commend the bill to the House.
Tom Rutherford.
Many people today have traversed the content of the legislation, so actually I want to spend just a brief moment actually acknowledging the leadership of the Minister himself. A really humble, diligent, hard-working Minister who won't want people to point out what he does in his role. But the first thing he does in states of emergency is get there on the ground, be with the people, hear them, listen to them, spend time with them. 19, I think it's 19 this term, and he has been there for all of them, and he has provided exceptional leadership on the ground, relatability, understanding them, understanding the situation, and he has used that to be reflective in this legislation, and I think he has done a superb job, so I want to put on record our thanks to him for his incredible work. I commend it to the House.
Tēnā koe e te māngai o te whare. O tira tēnā tātou katoa e mahi tahi ana mo tēnei pere. Ka tautoko awau i ngā mihi ki a rātou kua wehi atu, a rā ki a Rochelle, me ngā mea I hinga I roto I a Gabriel. Nā reira, hoki mai kia tātou te hunga ora, tihei mauri ora. I want to support the mihi to you, e te minita, for your proactivity during these times, and I have had the pleasure of being on the ground with you. Pleasure might be the wrong word, and I appreciate you and your staff as our wonderful spokesperson for this kaupapa, Camilla, has acknowledged, for including us and keeping us informed. I don't know if you're trying to make sure our emergency responders are so well prepared by creating all these disasters, but tēnei te miha atu kia koe. Mr. Speaker, there's so much I could say on this, so I will try and encapsulate it to one focus, and that is the value of local. When Gabriel hit us in Te Tai Rāwhiti, we were ready to go, because through not only our nature, but through COVID, Hapu had gathered, Hapu had organised, so we had teams on the ground in every community ready to go, ready to work with whichever organisation we had to, and indeed lead them because of the local knowledge. And I want to acknowledge everyone here who appreciate the value of iwi and marae. But I want to talk about what that really actually means on the ground. Recently, Camilla and I went to Uawa, and like all our communities, they had opened their doors. And I must acknowledge Pene Brown, who described to the then Minister, Grant Robertson, their response in Te Karaka. He said, our response was threefold. Our people, other Māori, and everyone else. And so when people open their marae, the impact is not just, hey, we're providing 4 walls and a roof. The impact is that these people, also volunteers, have to go to work in the morning. They're still worried about are the waters going to breach? Where do we go to? There's no roads. The impact is we're taking a resource out of the community. That marae is no longer available for 21sts, for weddings, for tangihanga even. So I think we need to take a deeper look at what we're talking about when we talk about iwi and marae responsibility. So on that note, there's so many acknowledgements I could make. And one, of course, is mahaki te aki tangata. Te Karaka was so badly impacted by Cyclone Gabriel. And one of the things we've learnt from that is while councils, etc., who do a great job, have monitoring devices, have technology, the reality is sometimes those cameras are about half an hour behind the local monitoring. So we've got people who actually stand by and go and man their rivers, monitor the levels, and then inform the councils and see them. So this is the true depth of iwi and marae input. And so while I acknowledge, I think we have to go beyond advising and embrace more leading. Because it was my work on this that really made me determined that Māori have to go from being the response to the decision makers. And so thank you, Minister, for the advance we're making, and we can certainly go further. I want to thank Mr Foster for acknowledging the investment that Labor made in the response through the PGF. Tēnā koe hoa. And acknowledge that that's another positive thing that's come out of this, is the level of resource in our communities. I've talked about Te Karaka, I want to talk about Tokomaru Bay and all our communities, Hauiti, who now have fantastic resources beyond the people. At the end of the day, the best resource we have in our communities are our people, but now they have physical tools in our communities. And I want to thank Ben Green and all the other amazing CEDM workers across New Zealand who are going into our communities and upskilling our people even further. Because we support this bill because at its heart, it's about manaaki. It's about looking after people. And the investment that's being made and that will continue to be made will make sure we have resources and even more skills and resilience to continue to care for our communities. I commend this bill to the House.
The Honourable Minister Lee.
Thank you.
Thank you, Mr. Speaker. I'd like to first of all start off by my acknowledgement to my learned colleague, Honourable Mark Mitchell, who has done an amazing job in this portfolio, and I thank him for this bill that's actually come to the House. This bill, apart from everything else that other members have actually said, this bill formalises and clarifies the concept of lead agency. I think that's a wonderful thing. And it reduces the ambiguity and clarifies who is actually making the decision so everybody knows who to follow. And this actually takes me to about 11 years ago. It didn't happen in New Zealand, it happened in South Korea, where a ship called Seymour sank, and 304 people died as a result, and 250 of the dead were students who were actually on a school excursion. That's 82% of the total who actually died. Out of the 172 who actually survived, more than half were rescued only by fishing boats that were actually nearby, and the Coast Guards were 40 minutes behind them. And the reason why that happened was no one actually knew who was in charge. There was no leadership. They did not know if the National Guards were in charge or the Coast Guards were in charge or the military could actually go and help. Even a foreign vessel, an American naval ship, was actually nearby and wanting to provide help, but they weren't allowed because they were foreign ship. And they could not actually help those children. And that is an utter disaster that I hope it never, ever happens in any other country. I commend this bill, which will make sure that it doesn't happen.
The question is that the motion be agreed to. All those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Emergency Management Bill number 2, first reading.
The question is that the Emergency Management Bill number 2 be considered by the Governance and Administration Committee. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Mr. Speaker.
Honourable Nicole McKee.
Mr Speaker, I present a legislative statement on the Arms Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
Thank you, Mr Speaker. I move that the Arms Bill now be read a first time, and I nominate the Justice Select Committee to consider the bill. Mr Speaker, over 40 years ago, Parliament enacted the Arms Act 1983. Since then, politicians have spent 40 years amending and rejigging the Arms Act 1983. Each change made was stacked on top of the next, rushed through in moments of political panic or patch-ups, until what's left is a law that is confusing for licensed firearm owners, inefficient for police, and ineffective at stopping criminals. New Zealand deserves better. Mr Speaker, public safety and respect for licensed firearm owners are not in conflict. They actually depend on each other. This bill starts with that simple premise. It rewrites the Arms Act in plain English with logical structure and practical improvements. The result is stronger firearm laws that better protects the public and a simpler regulatory system that supports compliance. Mr Speaker, the tragedy of 15 March 2019 was a day of unimaginable horror for this entire country, and none of us want to see that again. But the arms laws that followed were rushed, confused, unfair, and they punished the wrong people. They targeted the responsible, law-abiding New Zealanders instead of checking the systems and processes that led to this country's worst atrocity. They even negated really targeting criminals and gangs when they made their changes. Good law is not made in a panic. It's made with clear heads, sound evidence, and respect for those who already do the right thing. That is what this bill does. Mr Speaker, a core lesson from the past decade is that trust matters. For law to work, the public must have confidence in the system administering it. This bill creates a new independent firearms regulator to replace the Police Firearms Safety Authority. Its job will be to regulate clearly, consistently and transparently so that licensed firearm owners can comply without unnecessary burdens. It will operate independently of New Zealand Police with an independent chief executive, and no sworn police officers will work within it. Police will retain all the information that they need for enforcement, but their focus can shift to where it should be, pursuing the gangs and criminals who put the public at risk. The regulator will be empowered to provide clear guidance in consultation with the firearms community, so licensed firearm owners understand their requirements and can comply with their obligations. This bill also sets clear limits on what information can and cannot be recorded in the firearms registry, promoting transparency and building public confidence. Mr Speaker, I've heard the concerns about licensing delays, and this bill helps them. When New Zealand moved from lifetime firearm licences to 10-year licences, tens of thousands of people moved into the 10-year system all at once. So every decade since, the same surge and bottleneck has repeated for the same people. To put this into context, in a normal year, there are around 9,000 firearms licence renewals. This year, we are expecting around 55,000, and next year there will be around 50,000 renewals. To smooth this out, the regulator will have the discretion to be able to extend firearm licences for up to 3 years for some licensed owners whose renewals fall during the peak periods. Over time, this will end the bottleneck cycles each decade and create a steadier, more manageable flow of renewals. The regulator will also be able to issue infringement notices and educate licence holders for lower level offences rather than revoking a licence as the only option. This keeps people in the system and learning instead of pushing them out for behaviour that does not pose significant risk. Health-related suspensions are introduced and could last up to 12 months. Under the current law, many people lose their licence permanently simply because they needed more time to get help. That is neither fair nor proportionate. If a licence applicant disagrees with the regulator's licensing decision, a new independent firearms licensing review committee will hear their appeal. It replaces the current internal police-run process with a truly independent panel consisting of a lawyer, a representative from the firearms community, and an appointee of the regulator. Between October 2021 and March 2025, a third of appeals in the District Court resulted in a different outcome, showing exactly why this change is needed. The current Act, Mr Speaker, is not fit for purpose for people whose work or expertise requires specialised use of firearms. Pest controllers and biosecurity organisations perform essential work protecting our environment and agricultural community and economy. Their endorsements will be extended from 2.5 years to 5 years with a mid-term check-in. Multi-user agreements will allow restricted firearms to be temporarily transferred among approved pest control employees for up to 7 days without triggering unnecessary paperwork. Dealer licences will be renamed business licences to reflect the variety of modern firearms-related businesses we have. Compliant holders will have their licence duration extended from 1 year to 5 years, directly addressing one of the most frequent complaints that I have heard. Business employees will no longer require endorsements on their personal licences, subject to controls being in place. And gunsmiths will be able to conduct short-term repairs on restricted firearms without a permit to possess. Import permits will be extended from 30 days to 12 months, reducing administrative burden for both businesses and the regulator. New licence classes have been introduced for museum curators and their employees to reflect their unique circumstances, ensuring their rules are not disproportionate or so costly that they have to shut down. Collectors will also have greater flexibility around where the vital parts of a prohibited firearm must be stored. Mr Speaker, if we want to improve public safety, we must ask, who is driving the offending in New Zealand? And the answer, overwhelmingly, is criminal gangs. Gang members represent less than 1% of New Zealand's population, but are linked to around a quarter of all firearms offending. And this bill deals with that directly. It introduces automatic disqualification for gang members from holding a firearms licence, new offences for straw purchasing and diversion, offences to tackle 3D printed firearms made by unlicensed individuals in possession of digital files used for illegal manufacture, and significantly increases penalties for over 60 offences. Many have been untouched since 1983. This bill also clarifies product definitions, rules around manufacturing, and closes loopholes relating to large capacity pistol magazines and blank firing guns. For individuals who inadvertently find themselves in unlawful possession of a firearm, there are clear pathways now back into lawful ownership. One of the simplest and most important improvements is allowing secure storage at any regulator-approved location, not just a primary residence. Students that live in halls, renters, and many other people who are simply unable to meet the secure storage requirements will now have a safer choice for security. Mr Speaker, this bill balances safety, fairness, and practicality. It strengthens the law where criminals exploit it, and it simplifies it where licensed firearm owners have been burdened by it. It's not a bill that scapegoats legitimate firearm owners. It's a bill that fixes what matters. I encourage all New Zealanders to participate in the Select Committee process, especially those who will be impacted by this law. Consultation informed this law, showing that more voices make better law. This government values the vital role that farmers, hunters, sports shooters, pest controllers, dealers, museums, collectors, gunsmiths, and all licensed firearm owners play in our economy, our environment, and in our heritage. This bill is for them. And Mr Speaker, I'd just like to acknowledge that one of my staffers that has been working on this bill with me for the last 2 years is having his birthday today. Happy birthday, Matthew O'Connor. I now commend this bill to the House.
The question is that the motion be agreed to.
Mr Speaker.
The Honourable Jenny Anderson.
Kia ora, Mr Speaker. Thank you for the opportunity to speak on this bill, the Arms Bill. This bill is a major retreat by Nicole McKee from what was originally threatened or promised. But this is a major win for public safety in New Zealand. What was initially meant to be in this bill was enabling military-style semi-automatic weapons to be used on a gun range, that the Firearms Safety Authority would be taken out of New Zealand Police, and the Firearms Registry would be changed to exclude weapons such as A-category firearms. None of those things are in this bill, and that makes New Zealand a safer place. The fact that I held public meetings in Auckland, Wellington and in Christchurch on the risks of deregulating military-style semi-automatic weapons, that we ran a petition that got numerous signatures, that media engaged, that New Zealanders made it very clear that we did not want prohibited weapons, military-style semi-automatic weapons that were used in the Christchurch massacre made more readily available in New Zealand. And it is heartening that protest, that those voices were heard loud and clear, and that this bill does not make that dangerous change. I know there are many members of the Muslim community in New Zealand who will be grateful to see that that change has not been made. The Firearms Safety Authority also will remain in police. That was promised to be taken out of police. When we looked at the costs associated with that early on, we asked those questions and did not get answers, but it is now clear that the cost would be over $500 million to take the Firearms Safety Authority out of police. Also, what it does is it stops potentially that real-time access of intelligence. When someone has had their weapons removed, that is up front when police officers are attending in a call-out. That information is vital for the safety of our front line and for the safety of our communities. So we are heartened to see that the Firearms Safety Authority is staying where it is. The Firearms Registry also remains intact. The Firearms Registry commemorated a big goal just recently in November, with over 50% of those people who are licensed now using the registry for their weapons to be licensed through that. That is a huge testimony to the fact that people do not have a concern with trust and confidence, and that they are making sure that they use Te Tari Pūriki, the Firearms Safety Authority, and making sure that licences are now included in that registry. That is an intelligence map for our police to be able to use to know where the legal firearms are, and when we know when the legal firearms are, that makes it a lot easier to trace where those ones who have been diverted are going. So we still have some concerns with this bill, Madam Speaker, and I think it's important we point those out. The provision in this bill that no police will have involvement in the Firearms Safety Authority, or blue shirts as referred to by Nicole McKee in her press release. We've had no real reason as why we would not draw upon the institutional knowledge of New Zealand Police and firearms when making these changes to our Act. They are the ones that have the most experience and the most insights, and it does seem somewhat of an ideological move to remove police from having involvement. I'd be really interested to know what the Minister of Police has to say about police not having involvement in the FSA under its new restructured form. The second one we would like to know about is the funding. There's no clear indication of who's paying for this restructure, potentially up to 50 or 60 million for a full restructure of the Firearms Registry, but unclear whether that's coming out of a police budget and impacting on frontline services, or whether it's a Ministry of Justice budget. It seems like it'll be a separate budget bid, so we would be very interested to know who's paying. And finally, we want to know at the implementation dates that these changes will take time. We want to make sure they're embedded properly. For this reason, we want to make sure these changes are made appropriately. We'll be supporting this bill to Select Committee on the clear reason that we want to make New Zealand safer, and that we are heartened by the fact that those initial threats made by Nicole McKee of military-style semi-automatic weapons, Firearms Safety Authority out of police, and changing the firearms registry, all of those do not change. We think that this is a win for public safety in New Zealand, and it shows that we, even though we have a firearms lobbyist as the Minister, she's been unsuccessful in achieving her goals.
Madam Speaker.
Scott Willis.
Thank you, Madam Speaker. This bill, the Arms Bill, which repeals and replaces the Arms Act 1983, has the laudable goals of aiming to provide for greater protection for the public, simplifying regulatory requirements and improving compliance. So those are all really laudable goals, and the bill, as it stands, could well achieve some of these things. On public safety, as we've heard, there are good changes, such as recognising that multiple people within the system share responsibility for safety. Regulating blank firing guns, which we know have the potential to be transformed into live conventional firearms. Restricting high-capacity pistol magazines to endorsed licence holders. Requiring firearm businesses to notify the police of all surrendered firearms that will enable checks on those firearms to see if they have been involved in criminal activity or stolen, and requiring the regulatory approval for commercial ammunition sales. Now, these are all really good things, and there's a range of new offences as well which will address real risk and help future-proof things, like new offences like failing to notify the loss or theft of a firearms licence, the unsafe storage of firearms, possession of firearms without a serial number, possession of files that would enable 3D printing, as we heard, or intentional diversion. And as a parent, I really do support the change allowing licence holders to have secure storage facilities at any location approved by the regulator, such as in my gun safe rather than in a flat somewhere in Wellington that may not be as secure and may not be desired by the landlord. This certainly will reduce risk, and it is part of the really positive changes that we see in this bill. And I'm particularly pleased that the Associate Minister did not succeed in allowing greater access to military-style semi-automatic firearms. That's a rare moment of spine shown by National to stand up for something. But we know the Minister wanted to and still wants to give public access to military-style semi-automatic firearms, and we're concerned that some changes have been made more from spite than from any rational concern for public safety. So while this bill, as it stands today, does offer a number of improvements, it makes one big change that we believe will create more risk and reduce oversight and transparency. And for this reason, we will not be supporting this bill in its current form. Removing the regulator from the police seems more like a petty, vindictive act based on some vibes from some small group of firearms owners than any responsible act. The police have a unique and valuable perspective because they're on the front line of gun violence. They're often exposed to gun violence and they're at the greatest risk of gun violence. That free-flowing information flow is valuable in reducing risk, but their expertise is not included in the regulator, and that is extremely problematic. Instead of repairing the relationship and rebuilding trust between firearms owners, businesses and the government, the Minister has stripped the police of responsibility as some kind of weird punishment. The police should be involved in the regulator and in addressing violent crime rather than being tasked with responding to mental health issues. So we understand that this bill will proceed without our support and will move on to Select Committee. However, I would encourage the public listening and my Labor colleagues here to seek the retention of the regulator within the police, reporting to the Police Commissioner, because we can't allow some petty punishment for some imagined slight to reduce public safety by removing police oversight. The police who deal with violent crime and gun violence, removing the police just increases the risk to the public, and for this reason we oppose the bill in its current form.
I call Carl Bates.
Thank you, Madam Speaker. Madam Speaker, this Act is designed to ensure that we promote the safe possession and use of arms. And there's a couple of things within the Act, or within the bill rather, that I thought I would highlight as part of that objective. The first is the clarification of the 60 offences down into 8 offences. I think that really ensures that we're clear that there are offences for doing things wrong, but we make them easy to understand. And secondly, the independence of the Firearms Licensing Review Committee. So therefore I commend it to the House.
Madam Speaker.
I call the Honourable Dr David Wilson.
I rise on behalf of...
not the Honourable, just the Dr David Wilson. Thank you.
I'll respond to both.
Okay.
I rise on behalf of New Zealand First in this first reading of the Arms Bill. We'd like to commend the Honourable Nicole McKee for her work on this bill. Relevant, practical, balanced. This bill is not about ensuring New Zealand's firearms laws are fit for purpose in the 21st century. Should I say that it is about that? The Arms Act 1983 has served us for decades, but recent events and reviews have shown gaps in licensing, compliance and enforcement. For example, responding to the emerging technology in firearms such as 3D printing. The Arms Bill strengthens oversight of firearms ownership, dealers and clubs while ensuring legitimate users can continue their activities under clear and fair rules. New Zealand First has always stood for balance, protecting public safety while respecting the rights of responsible firearms owners. Our party policies have consistently emphasised the need for strong licensing, secure storage and tough penalties for criminals, while ensuring that hunters, farmers and sporting shooters are not unfairly penalised. We believe in practical, enforceable laws that target misuse, not tradition. We support this bill because it delivers exactly that balance, Madam Speaker. It strengthens police powers to deal with unlawful possession and trafficking, ensures dealers and clubs meet modern standards, and introduces tougher penalties for those who misuse firearms. At the same time, it provides certainty for responsible owners, recognising their role in rural life, food production and sport. For New Zealand First, this bill is about fairness, ensuring criminals face consequences while law-abiding citizens retain their rights. Madam Speaker, we commend this bill to the House. Thank
you. Madam Speaker. I call Orini Kaipara. Thank you.
Tēnā koe. Thank you, Madam Speaker. Before setting out Te Pāti Māori's position on this bill, I want to acknowledge the wider context we're debating it. Across Aotearoa, many communities are confronting rising violence, deepening inequality and ongoing pressures that disproportionately affect those with the fewest resources. Those communities, as we very well know, are tangata whenua. Firearms legislation sits at the crossroads of public safety, political influence and community wellbeing. How this House chooses to regulate firearms is not just a technical exercise, it reveals whose safety is valued, whose voices are centred and whose interests are given priority. It is in that context that I rise on behalf of Te Pāti Māori to oppose the Arms Bill 2025. Our position is clear. This bill shifts power away from the community safety and toward political interests, including powerful firearm lobby interests, while failing to address the real drivers of harm in our communities. This bill includes over 50 separate policy changes. It rewrites more than 60 existing offences and creates 8 new offences. It loosens rules for firearms users, pest controllers, collectors and dealers, and it establishes an entirely new firearms regulator deliberately distanced from sworn police oversight. And we must be honest about where this direction is coming from. This government's decisions appear aligned with the interests of lobby groups rather than with the people most affected by gun violence. The move to hand all regulatory powers to a new independent regulator is not necessarily about improving safety, Madam Speaker. It risks politicising gun control and weakening safeguards that were strengthened after the 2019 Christchurch terrorist attacks. Recent data suggests that gun crime in Tāmaki Makaurau is rising, and that the majority of these offences involve illegally owned firearms, not licence holders. This trend shows that loosening regulation doesn't necessarily help the people, like our hunters, who use firearms responsibly, but rather may benefit those who obtain guns illegally or misuse them. From a Māori worldview, whānau who use firearms responsibly for hunting, pest control, or mahi on their whenua contribute to the oranga or the well-being of their whānau and whenua. Our concern is not with them, our concern is with protecting life, whakapapa and mana, which demand strong and culturally informed regulation. If this government were truly serious about reducing gun harm, it would invest in whānau support, violence prevention, housing security, mental health services, kaupapa Māori responses, and action against illegal firearms, not deliver a bill shaped by lobbyists with weakened oversight that sidelines the voices of people living with the consequences of gun violence. Therefore, Te Pāti Māori cannot support a bill that, under the guise of reform, shifts power away from community safety, risks public safety, and ignores the real issues facing our people, not just Māori, but all New Zealanders. The responsibility of this House and of this government is to protect our communities, our whakapapa, and our mokopuna, not to appease political pressure groups.
Madam Speaker, let's clarify two things for the previous speaker. Purpose of the Act, promote the safe possession and use of arms. And secondly, impose controls to prevent the possession and use of arms for criminal activity. It's a good thing, Madam Speaker. It's a really good thing for New Zealand, and therefore I commend it to the House.
I get a refund. Madam Speaker, for many people in Aotearoa today, this is actually a moment of relief. And the strange thing is that it's a moment of relief not because of what's in the bill, but because of what's not in the bill. For so many people, they've been concerned that the shift we'd be discussing today would be a shift to change our position on semi-automatic weapons. And that is not the case. That has been a failed attempt today because of the work on this side of the House, but also because of the work of many people in the Muslim community and many people in the community who've been lobbying against that. So I did want to just acknowledge Philippa Yazbek from Gun Control and the important work that she's done, but also the Federation of Islamic Association chairperson Abdul Razak, who said one of the key legacies of the 51 Shahada was to make New Zealand safe, particularly from the menace of the semi-automatic killing machines. So this is an important moment to mark what grassroots campaigners, what our ethnic communities can do when they have their voices heard by this House, and I think it's extremely powerful. We will be supporting the bill through to Select Committee, but as the Honourable Ginny Anderson has said, there are concerns that we have and things that we will be raising. The bill is a significant one, 232 pages to go through, and I'm looking forward to really robust submissions from those in the community about the detail of the bill. I do want to acknowledge the officials who produced this great document called Arms Bill Explanation of Proposals. It has an excellent spreadsheet that goes change by change through what the law is now and what the changes will be. A huge aid in terms of making those submissions. And I wanted just to speak to some other choices that have been made in the body of the bill, which I'll certainly be questioning at Select Committee stage. So The first one is in relation to the health-related licence suspension. So right now, if people are deemed not to be in a sufficient state to hold a licence, those licences can be suspended for 3 months. And if the licence is not reinstated in that 3-month period, then it expires. The person cannot apply for another licence for a 10-year period. Now, there's a change in this bill that extends that to a 12-month suspension. On the one hand, it feels like that would mean a potentially safer community because those licences can be suspended for longer. However, it also gives the person the opportunity to remediate whatever the issue is, which then avoids the 10-year problem. So it's a choice that's been made that strikes a particular balance. The question is that balance the correct one? Another interesting one is around the definition of penalties and what constitutes premises or not. So the current law assumes that you must keep the licensed firearm in a secure place within your premises where you normally reside. Now, for many people, that's not going to be the place where they normally reside. And the example used in the document provided by officials was students, for example, who may be flatting elsewhere but may need to keep their firearm in a location that's separate from where they live. So some extremely sensible changes made, including changes around the printing of parts of what could be used as a firearm. So acknowledging that technology is developed in a way that means we now need to accommodate for that. There is Section 7 Bill of Rights Act advice to the committee on this as well that says that the bill is compliant with the Bill of Rights Act. However, there are a few matters to interrogate for the committee as we go through select committee stage. One is around freedom to relay or not to relay information, and the requirement that people have to disclose their personal details to the police when asked. The current assessment is that that is a fair limitation on rights, but I do think that that is something that the committee will need to interrogate, and I certainly hope we receive submissions on that, Madam Speaker. So for the time being, I do commend this bill to the House, but again urge submitters to come having read the spreadsheet and just give us our assessment on whether they believe that the ground struck between some of these difficult choices is the correct one. Thank you.
Thank you, Madam Speaker. My favourite proposed change of the arms bill is that if someone chooses to be a member of a gang, then they will be automatically disqualified from holding a firearms licence. I commend this bill to the House.
Helen White.
Thank you. First of all, I want to reiterate what Vanushi Walters just said about the great deal of relief that people will feel that we are no longer looking at semi-automatic firearms coming back into our communities. That's an incredibly important thing. I was very aware of the stress that was causing and the way that people felt about it on the ground, that they felt that there had been, there was not sensitivity around what happened in this country. And I, like many other people, will remember exactly where I was on that day as this terrible, terrible event unfolded in our country. But I wanted also to talk about my portfolio, because I have the sexual and family violence portfolio and the implications for people of this law. I am very pleased to see this going forward in the form it is to the Select Committee. But I too am concerned about the police not being as involved as they were, and I don't really understand why that is. And I would urge people who are submitting, who have had experiences, particularly experiences of domestic violence or fear of domestic violence or family harm, to come forward and to tell those stories, and for the Select Committee to be sensitive about how they get to tell those stories, because they're often very fearful of doing that. And I wanted to talk about an incident the other day that happened when we were in Scrutiny Week, and we had the Justice Committee move to the part of scrutiny which was about the Sexual and Family Violence Centre. And as we spoke about a particularly serious and very worrying new development, which is a lot of promotion of rough sex on the internet, and people being involved in situations where they were simply confused about whether they had a right to be upset about what had happened to them, or to claim that was abusive behaviour, because things have just moved so far. And as we talked about that subject, a police officer who I'd actually given a pretty hard time to about the call-out changes from police, and I thought that she probably didn't necessarily like my questioning, but she came to the front of the room and she said it made her hackles rise, because she was seeing the very behaviour that I was discussing on the front line over and over again, and we needed to do something about it. And I thought about the value of her role as a police officer in that situation. Our police are absolutely in the front line, and people like the woman that came into that situation, they have a very grounded, realistic view of complicated issues. They get to see things I wish I never saw, and they do carry that experience and that responsibility. And if you look at this bill and you think about that experience and responsibility in the context of people who may harm their family members with guns, may be subject to mental distress, may be angry, it's really important that our police who see that participate in this process. So I have a strong belief that the police should be involved in this process, and I would really like it looked at the Select Committee as an issue. And I take my friend Venushi Walter's point that the 12-month suspension probably has arguments for and against it, and I'd really like that looked at that time, and with an open mind, because these bills, they make a difference to whether people live or die, and it's a really responsible thing to do, to listen to our submitters and think through these things with an open mind. I commend this bill to the House.
I call Mike Busherick.
Thank you, Madam Speaker. This is a good bill because it clarifies the law and closes some loopholes. And as my good friend Rima Narkley said, it also makes gang membership an automatic disqualifying factor for holding a firearms licence, and that's a good thing. I commend the bill to the House.
The question is that the motion be agreed to. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it.
Arms Bill, first reading.
The question is that the Arms Bill be considered by the Justice Committee. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it. Members, I call on order of the day number 2.
Speaker.
Honourable Chris Bishop.
I present a legislative statement on the Fast Track Approvals Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
I move that the Fast Track Approvals Amendment Bill be now read a second time. Madam Speaker, it's a privilege to be back before the House to present the bill for the second reading. When the bill was introduced on the 3rd of November, I said and repeat again that the bill has 2 complementary priorities. The first is promoting competition in the grocery retail sector, advancing a core part of the government's Going for Growth agenda, which will have flow-on effects for productivity and living standards. The second is to make changes to improve the Fast Track regime's workability and efficiency. Fast Track is working pretty well, actually, and we've had a number of projects that have already been consented and received approval. In fact, some of those projects are underway, like the Ports of Auckland expansion or extension and the new ferry or the new cruise ship terminal. Maitahi, which I'm visiting tomorrow, which is a housing development down in Nelson. Fast Track's working pretty well, but all regimes, particularly ones as complicated as Fast Track, benefit from fine tuning. So over the course of this year, there has been feedback sought from targeted engagement with applicants, with agencies, and the panel conveners themselves actually, who are doing a good job processing all these applications to try and find operational and procedural efficiencies. So the bill includes a range of amendments to speed up the application process, reduce timeframes in key areas, improve flexibility, and to clarify a range of operational matters. I do want to acknowledge the Environment Select Committee, who have had a short but thorough look at the approvals amendment bill, hearing submissions and considering the bills. There were many submissions made during that short process. There were quite a few themes that came through from submissions, including if proposed changes would allow for consideration of environmental issues, how they would accommodate treaty and other arrangements with Maori, concerns about government input in the decision-making process, representation for local communities, the GPS process, the government policy statement process, and timeframes, including for panel decisions. Some submissions concern changes to the current Clause 42 of the bill, under which parts of an application can be withdrawn after an application has been lodged. Some submitters expressed concerns this change could lead to project scope being expanded mid-process. The legislative process has led to a clarification. Modifications cannot be made that result in the application expanding the scope of the project beyond its original description in the referral application or as it was listed in Schedule 2 of the Fast Track Approvals Act 2024. Ministerial direction in this area is intended as a backstop in the event expert panels are uncertain if a project, if modified, will continue to have significant regional or national benefits. This makes it clear that expert panels can continue processing applications as modified without seeking a direction from the Minister. Several submissions reference previous mining cases or applications under the RMA or concerns regarding long-term environmental risks or considerations. The bill does not seek to change the expert panel's role in determining whether identified adverse impacts are out of proportion to the project's benefits and to impose appropriate conditions on approvals. The bill introduces a new requirement for applicants to provide information on effects in their referral application, which will help inform ministerial referral decisions. The Minister for Infrastructure has the discretion to decline a referral application if it would have significant adverse environmental effects, and I note that I have declined some referral applications already through the fast track process. Changes will be made to several key timeframes for decisions in the fast track process. Decision timeframes to date have varied due to the complexity of individual applications. However, in line with the Act's requirement for efficient processes, clear statutory timeframes give applicants and investors greater certainty about process and cost. Having heard submissions, it is sensible to increase the maximum time limit for an expert panel's decision from 60 working days to 90 working days, which can still be extended with agreement from the applicant. The timeframe for parties to provide comments on referral applications is reduced from 20 to 15 working days. Regional councils must respond to requests for information about existing resource consents within 10 working days. Previously, there was no previous statutory timeframe. The intention is to achieve a balance between the requirement for timely information and the need to maintain accuracy and avoid placing unreasonable burdens on councils. The panel convener and others provided informative submissions on how reducing the time taken to establish panels may not be workable in practice, and the government has established it as preferable to maintain the status quo and have no statutory timeframe for panel appointments. Efficiencies will be realised when certain steps in the substantive process, such as completeness checks and competing application checks, happen concurrently. Applicants invest significant time and resources, and it doesn't make sense that they should be penalised if application circumstances change and they want to pause their application. The maximum time that an applicant can request the suspension of their application is proposed to be increased from 50 to 100 working days. This is to allow applicants more time to provide information to address concerns raised by parties invited to comment on applications. In relation to government policy statements, these were proposed so projects' regional or national benefits were more easily related to government policies and priorities for development or growth across a range of sectors. They will be issued by the Minister for Infrastructure. GPS set out the government's policies on the regional or national benefits of certain types of infrastructure or development projects. The Minister for Infrastructure will consider any relevant GPSs during the referral process. The expert panels will do the same, when deciding whether to approve a project or set conditions, or approve a project and set conditions or decline them. Some submitters were supportive of the GPS mechanism as drafted and thought it would provide greater clarity and certainty for nationally significant issues. Others considered the grocery retail GPS a good template for future development in other areas, such as urban development and to enable infrastructure. Developing GPSs will not happen in a vacuum. Section 10A of the amendments outlines how they will be issued and who may be consulted. The bill amends a number of project descriptions and updates the respective project descriptions, locations and authorised persons, including for the Stella Passage project. There are also transitional provisions to ensure fairness and clarity for applications in progress. Any changes that do not require system or IT updates will take effect immediately. Some changes that require system updates will take effect on 31st of March 2026. The bill's legislative process has delivered a range of sensible outcomes that, if adopted by the House, will balance the need to improve Fast Track's efficiency and workability while still preserving the ability to facilitate regionally and nationally significant infrastructure and development projects and deliver robust decisions. As I say, Fast Track is working well. We have listened to some of the feedback that's come through the Select Committee process, who I think did a good job hearing the submissions. Members will note that the government has lodged an amendment paper yesterday actually, which is available for everybody to see. So as we get into the Committee of the Whole, we can work our way through that, which picks up on some of the submissions. My understanding is the Select Committee did not do an RT version, so essentially the Committee of the Whole House stage is the ability for the House to make amendments to the Fast Track Approvals Amendment Bill, and I'm looking forward to considering that in the Committee of the Whole. As I say, there's twin objectives to the bill. One is around grocery sector competition, which I think is broadly supported across the Parliament. I think I'm right in saying that. And the second is some efficiency and workability improvements to the original Fast Track regime. Having decided to do the grocery sector competition, the government thought it was worthwhile making these sensible finesses and tweaks to the Approvals Act. As I say, it's working well. Everything can be better, and that's the aim of this bill. Thank you.
The question is that the motion be agreed to. I call Honourable Rachel Brooking.
Thank you, Madam Speaker. And I'm interested in one of those last remarks from the Minister, that he acknowledges that there is general support from around the House for increased grocery competition. And if he will remove his Facebook post that he made immediately after the first reading of this bill, saying that Labor didn't support supermarket competition, that Labor had voted against it. And then noting his further comments that he made, whereby he said, oh yes, and I'm paraphrasing somewhat, Labor has some fair points about the fact of the supermarket competition being entwined with a whole lot of other issues, but they can vote on that clause by clause when we go through the committee stage of the bill. So I hope the Minister holds to that. My main point, of course, is this bill is not about supermarket competition. If it was about supermarket competition, we would have not been rushing this through the Select Committee in the way that we did, and there may be general agreement about all of the changes, but Madam Speaker, there is not, because what this bill is about is enabling ministers to delve down into the substantive decision making on these decisions. These are decisions that already have normal environmental protections degraded, Madam Speaker. And that is the problem with the Fast Track Act, the Principal Act, and what this bill does is make it even worse. It's not about speed, it's not about a one-stop shop, it's about ministers making decisions. And we saw when the Fast Track Bill, which is now the Principal Act, when that first came out some time ago, there was talk of Muldoonism. And the Minister says he doesn't like Muldoonism, and that in fact he has Fitzgerald and Muldoon on his wall. But and we had protests down Queen Street, and Glenn Bennett was at that protest, and it was all the way down Queen Street because people were particularly worried about ministers making decisions on important issues that need to be considered with evidence in front of a robust decision-making process. That seems like something that the Attorney General would want. And the change was made. So the ministers in the Fast Track Act do not have that ability to make the decisions. But what this bill does is introduce a new mechanism, a government policy statement. A government policy statement that is made on the whim of the minister. There are no criteria. There's a little amendment that's just been made that, they can consult other people if they want to. Whoop-de-doo, Madam Speaker. That is not a robust process, that is not criteria, and it is different from other pieces of legislation, apart from, of course, the recent amendments to the Crown Minerals Act, whereby there are criteria for anything that is called a government policy statement or words to that effect. So I have suggested an amendment, which I hope the Minister will consider, that provides some criteria for that government policy statement. Now, if the Minister was committed to this bill being about supermarket competition, then the provisions in the bill could specifically refer to supermarket competition, that the government policy statement is to be about grocery competition, but it does not do that. No, it is much wider, and that is the concern that we have, and that many submitters, many very thoughtful submitters, including the Parliamentary Commissioner for the Environment, amongst others, about how this, and even the New Zealand Institute, about how this is ministerial overreach, and it is very serious. So that is one issue. Another issue, Madam Speaker, is the process through which this bill has gone through to this point. Normally, if we're reporting back from a select committee that has a report back period under 4 months, there would have been a debate in this chamber from members across the chamber about that shortened time frame. This did not happen for this bill. Instead, the chairperson decided to have a very short submission period, and then the majority of that select committee agreed to report back early. That is not a good process. So it meant, and the select committee did work very hard, and the officials all worked very hard as well, and I of course commend their dedication to doing their job and being good public servants. But it did mean that we did not have a long time for submissions, and of course we haven't got an RT, a revision tracked version, with the select committee report back. The Minister just referred to the amendments coming in yesterday. When I was looking for his amendments yesterday, I could not find them. I note that they have been tabled now for at least an hour or so, and I have been going through those diligently and will refer to them at some length in the committee stage. But that is not a good way of making laws, and it also has meant that a whole lot of submitters brought to us good points. Now, the Minister has described this bill as supermarkets and rats and mice. There are some rats and mice in this bill, and being from Dunedin, I'm careful when I talk about supermarkets and rats. that is Speaker. I note the Minister for Food Safety is in the house. And it's just outside my electorate, on the other side of the road. And thank you for the offer of cats. So, Madam Speaker, though, whilst there are some small issues, there are also these bigger issues that I've been talking about, and it would have been, if you're doing a tidy up of a bill that you've only passed a year or so ago, and I'm all for reviewing bills, and all for having good regulatory systems, then we could have had a good, robust process. So, for instance, Queenstown has an awful lot of listed projects that relate to Queenstown, and Queenstown's population is not giant, and the council has limited ratepayers and limited resource. And Queenstown is a beautiful place, and it is growing, and the council has been trying to plan for its infrastructure and where that additional housing growth should go for a long time. And it's very important that there are more houses in Queenstown, Madam Speaker. Nobody is debating that point. But the councils from both Queenstown and Central Otago District Council, so that includes Cromwell, where there's a lot of commuters living who go in and work in Queenstown, they came to the Select Committee and said, look, Queenstown has the most unaffordable housing in the country. Queenstown has had special legislation about housing before. Nick Smith did a special housing accords piece of legislation, And as a result, there was a requirement for affordable housing. Now, they made the submission to the Select Committee, look, we're the ones with the most unaffordable housing in the countries. We are the ones with the most per capita fast-track applications happening here. Surely there is an argument for a specific requirement for those developers who will be getting huge uplift from rurally zoned land that will now be developed with housing. Surely there is an argument for a special requirement for, say, 5% affordable housing in those projects. And that seems to me like a very legitimate argument. I, of course, don't want to make a decision on it because we haven't heard any analysis from officials about that, because, of course, there was no time to do so. And that is a missed opportunity, Madam Speaker. And that is because this government continues to want to just rush things through and not have some good thought to what is actually happening. And we're going to have many questions about the amendment paper that the Minister has put up about what the consequences of the changes are, because, again, we have not had that analysis. Now, Madam Speaker, there are many other changes in this bill that are not to do with supermarkets or rats and mice. And some of them are to do with limiting participation of other groups, and there are some changes in the amendments that we'll talk to in the committee stage. But particularly, we heard from iwi groups that the timeframes in the fast track at the moment are already near impossible. So any further reductions of those timeframes will mean that their participation is mere rubber stamping. They cannot do substantive, thoughtful contributions, and that is what we want, because we are concerned here about our environment and protecting it. Thank you, Madam Speaker.
Madam Speaker. Thank you, Madam Speaker. Are you doing it? General tree protection, I'm happy to talk about that, because 100 years hence, Madam Speaker, 100 years hence, an anthropologist will take a bird's eye view of this particular moment in history and this particular government and this suite of bills that have been rushed through the House without democratic process or proper consultation or consideration or any respect whatsoever of the constitutional foundation of this nation and te tiriti o Waitangi and hei whakaputanga. And they will go, that was the point. That was the point when Aotearoa set itself on a path to ecological ruin under the manic ideology of corporate power, anarcho-capitalism, whereby our view of the world is shaped entirely by the idea that private property rights and the accumulation of money is the most important human value there is. You only have to look at some of those ancient books of old that tell you that the accumulation of wealth is not good for anybody. It is not good for the planet, it is not good for people, it is not good for communities, and it's not even good for the people who accumulate the wealth at the end of the day. There is no version of a life on this planet that is not centred around protection of the basis of that life, which is the health of our ecology. The bill before us today is a worsening of what was one of the worst pieces of legislation this government passed, the fast-track legislation. And what is more, as my colleague just pointed out, they've just dropped a stack of amendments on this bill. So we haven't even had half a minute to read through what those amendments are, but we will certainly be debating them over the course of the next few hours. One of the most egregious parts of the fast-track legislation, and this bill makes it worse, is that it takes community out of decision-making. It takes local iwi out of decision-making. It takes the environment out of consideration insofar as it dismisses the upholding of our existing environment laws, and it certainly has no regard for climate change, the existential challenge that threatens us all. And so, we made a commitment as the Green Party that we would correct this extreme legislation and the things that it has committed to make happen. The basis of that commitment is a recognition that there is an appropriate place for development, there is an appropriate pathway for people to get a consent and a permission to undertake certain activities, business activities or whatever they are, or farming or whatever you like. But it must be with the consent of the people. It must be consistent with Te Tiriti o Waitangi. It must be consistent with protecting the common good, the health of our rivers, the health of our atmosphere, the health of our oceans, and our biodiversity. Because those are the things that it is the first duty and responsibility of the regulator and the legislator to protect. It is our responsibility as parliamentarians to protect the public good and the commons from those who would exploit it and harm it and destroy it. That's our job, Madam Speaker. This fast-track bill seeks to bypass that responsibility. And one of the more egregious things that it does is it allows projects that have been through a substantive and an extensive process, such as the Taranaki seabed mining project, which has been rejected and resisted by community in iwi and Taranaki for more than a decade, is opposed by even the commercial fishing industry, is opposed by the offshore wind industry, who have been put off the prospects of building offshore wind in Taranaki because of the prospects of seabed mining by Trans-Tasman Resources, bless you. It is a zombie project, Madam Speaker. It has been rejected by all of the courts and tribunals in this land, including the very Supreme Court. The Supreme Court sent it back. It is dead, buried in the ground, and this Luxon government resurrects it through the fast-track process. And it is shameful. It is so disdainful of the inordinate hours and time that communities have spent to say, this is not what we want for our country. Oh, but no, this government's first duty is to some Australian speculator, Trans-Tasman Resources, who want to destroy the seabed off Taranaki for 35 years straight. So we, as Te Pāti Kākariki, wanted to make it clear to industry that this sort of a process by which consents are achieved will not stand under a Green government. We set a line in the sand that stretches from Bream Bay to the sandstone cap of the Denniston Plateau. And that line in the sand is a commitment that any consents issued by this government through the fast-track process for coal mining, hard rock gold mining, or seabed mining will be revoked. That is because of how inappropriate this process is. It is a significant act to take and to commit, but that is because this is such an egregious piece of legislation that does not respect biodiversity, does not respect democracy. The message to the mining industry today is that you should not take any heart from this fast-track amendment bill. It does not give you security of tenure. It does not give you a certainty in the future because there is not political support for it across the House. And when there is a change of government, you can be certain this bill will be either entirely thrown out or substantially amended. And what is more, it is a high priority for the Green Party if we are in coalition negotiations with any other party, that we will stand on what our commitment is, that we will revoke the consents for the destruction of the spectacular 40-million-year-old ecology of the Denniston Plateau for Aussie gold miners. That ain't happening. We will stop Trans-Tasman Resources seabed mining. We will stop the mining of Bream Bay for sand. We will stop the Waihi. You should have a look at the fast-track application, Simon. There's about 7 other sand mining applications. There's plenty of places to get sand without dredging the seafloor.
Back to speaking to the bill, not across the House, in a conversation, please.
Sure. We will revoke the hard rock gold mining in Otago, Bendigo and Macraes and Waihi. Why? Because those forms of mining use cyanide to extract the gold. They leave a toxic legacy of arsenic and cyanide tailings dams that are there intergenerationally, long after any jobs have dried up and the profits have been repatriated to Australia. That legacy is there. The acid mine drainage that we saw in the Hiniwai River down in Coromandel was from a mine 100 years old. Anyone who had worked in that mine was long dead, and probably their grandchildren were dead. This is why this form of extractive, destructive industry is not the future for our country. We need a future based on renewable industries. And we have made a commitment as the Greens, as an alternative to this, just to be clear, that we can create 40,000 jobs plus through renewable industries and backing Central North Island timber processing among other things, but also keeping the mills open that this government is letting close. And they can't afford the energy because you won't reform, I should say they, Madam Speaker, won't reform the electricity market and break it with generator retailers. Get on with it. Fix the problem. Madam Speaker, we will certainly be opposing this bill. This sort of reckless disrespect for people and planet and Te Tiriti has no future. Thank you.
Madam Speaker.
Simon Court.
Thank you, Madam Speaker. Well, wasn't it an eye-opening speech from the Green Party member, Steve Abel, who I do have a lot of respect for his commitment to the environment. I mean, he spent over 240 days in a tree in West Auckland to stop a property development. I'm not sure if those houses have ever been built, so there's probably 240 people who don't have a warm, dry home. But I do respect his commitment to the environment. Even though when he starts to mix up Kiwis' care and appreciation for our natural environment with, and therefore everything must be collectivised, we must nationalise the energy system, and what did he say? That development requires consent of the community. Well, of course communities must have an input into development. The fast-track process allows for views to be gathered, but we can't allow a right of veto to every Tom, Dick, Harry who turns up at a hearing and gives their reckons and vibes as to why something like a housing development or a mine shouldn't go ahead. Now, what does this bill do? It's quite simple. It provides for grocery businesses, supermarkets, to demonstrate that there's a national and regional significance test that they pass so they can use the fast-track system. What else does it do? It establishes a more efficient process for fast-track approvals, which means that instead of applicants having to spend tens of thousands or hundreds of thousands of dollars stacking up technical reports to demonstrate why every risk is managed down to the nth degree, why things you can't even see, touch or feel are managed in a way that the collectivists over there on that side of the House approve of, we are providing a much more efficient pathway. And I want to tell that member, Rawiri Waititi, the story of New Zealand has been people on the other side of the House objecting to development, threatening to nationalise successful businesses that deliver electricity and food to consumers. And that's not going to work for New Zealand. Everywhere that collectivisation and collectivism has been tried, it's led to famine, poverty, the destruction of institutions, the collapse of civil society. You think of Cambodia under Pol Pot. You think of Russia under Stalin. That is what you're advocating, Steve Abel, and that is what you are riding shotgun on, Rawiri Waititi. Now, why is fast track an important part of the development approvals process? Well, firstly, it recognises that under the Resource Management Act, the Wildlife Act, the Conservation Act, the Public Works Act, that there are approvals needed for many different aspects of a development. And what fast track does is simply bring them all into one place so that all the evidence can be considered at one place, at one time, by one group of planning commissioners. Now, if you think about viewing the world in a holistic way and balancing human needs with nature, you'd say actually the fast track approvals process pulls all these things together in a really coherent way, which is why it's such a struggle to understand as a civil engineer the incoherence and frankly the lack of rationale behind the arguments that we've heard from the left and hard left green wing of politics in New Zealand. I can't understand why someone would bother, like Glenn Bennett, marching down Queen Street to protest against a bit of legislation that makes housing development and getting vital minerals out of the ground easier. I mean, if you honestly think, Steve Abel, you mentioned that there's a whole bunch of other places we could mine sand on land instead of the ocean, would you turn up and write a positive letter saying the Green Party would love you to do more sand mining on land? Like, would you turn up at the hearing and say the Green Party loves land sand mining? Because I don't think you would. I don't think that that's a fair reflection of the Green Party's views. In fact, I think they're 100% anti-mining anywhere ever. And if you really, really believed in that, you'd hand over your cell phones, you'd hand over your laptops, you'd refuse to fly anywhere, you'd be as sound as Greta Thunberg. You'd only come and go from Parliament by boat.
Can I just ask the member not to bring the Speaker into your debate?
Madam Speaker, I do apologise for bringing you into the debate, but I will reflect that Greta Thunberg, even though she's completely wrong about everything, at least has the courage of her convictions to travel to and from the places she wishes to protest and speak at by sailing boat. She's only ever flown on a plane when other people have said, Greta, you get to sit next, Greta Thunberg, you must sit next to the toilets at the back of the plane. And I don't know, maybe that's the kind of sacrifice even the Greens would be prepared to make. But I doubt it, because they don't have the courage of their convictions to say, actually, there should be some mining somewhere, and we will say where it is because we know it's important to New Zealand. Now, this bill is important. We must have a one-stop shop to consider complex development applications. For far too long, the Resource Management Act has made it almost impossible to consent to things we need in a reasonable time frame and a reasonable cost. It doesn't mean these projects won't proceed. Of course they will. But why would we hold applicants, developers, even the Crown to an impossibly high standard where every single risk must be managed down to the nth degree until you can't see it, or even if you can see it, you know it's there, it's still a risk. That's what the RMA does. Fast Track cuts through this. But what's coming next is going to be even better. We're going to replace the Resource Management Act that has caused all this problem with two new bits of legislation, a Planning Act and a Natural Environment Act, based on property rights in the Planning Act, being able to use your land without having every Tom, Dick and Harry turn up to object to the colour of your front door, and a piece of legislation to establish environmental limits. Now, the opposition doesn't disagree with that. They love environmental limits, and they also love living in houses. So, you know, some of these problems we're trying to deal with the fast track are actually to deal with this legacy, this kind of 1980s cool kids vibe, sustainable management crap that we've had to accept holding us back for over 30 years. Fast track is going to help, but replacing the resource management system with a new system based on property rights is the new game in town. New Zealand's going to have the best planning system in the world. Green parties, I predict, from other countries will come to New Zealand to ask, how did you do it? How did you protect the environment and build homes that people want to live in and have mines? Well, New Zealand's going to show them how. This government's going to show them how. Madam Speaker, ACT is proud to support this amendment to the Fast Track Approvals Act.
Jamie.
What?
Thank you, Madam Speaker. I rise on behalf of New Zealand First to support the Fast Track Approvals Amendment Bill in its second reading. And as I did mention in the first reading of this bill, this is a core part of the National New Zealand First Coalition Agreement. And it is, yes, I remember back to that time around those coalition discussions, and this piece of legislation was something New Zealand First had developed and popped onto the table at those coalition agreement talks, and it's a proud moment to actually see this piece of legislation in the House being refined and actually working the way we want it to work. So it's about letting the investment flow, and Mr. Speaker, we need to let the investment flow and we need to let the activity flow. There is too much in New Zealand with stopping activity, and this bill will actually get the wheels moving and get the economy moving. As I mentioned, Mr. Speaker, it's about fine-tuning. It's about getting the legislation working in the way that we want it to work. And obviously, when the first part of the legislation came through, there has been the need to bring it back, to fine-tune it. And one of the great things with the fine-tuning here is we're going to see in the supermarket industry that we're all shouting out for is we want to see more competition. And in the supermarket industry, if we don't get competition, if we don't get new players into the market, we aren't going to see prices come down. We want to see the competition, we want to see new players coming into the country. It's fantastic that the Maori Party's actually agreeing with me. We want to see some competition, we want to see more dollars in everyone's pockets so we can see competition into the supermarket industry. And we're talking, Mr. Speaker, of a 6-week reduction. So 6 weeks of red tape cut out. If we can cut out 6 weeks of red tape of having to go through processes that aren't required, will save costs. It will get shovels into the ground and we can get projects underway. And I can't believe that the Labour Party spokesperson is disagreeing with me, but we'll carry on and have a little bit of a discussion about that a little bit later. The other thing about this piece of legislation is it will create jobs now. And we know in the regional New Zealand and across New Zealand, we want to see jobs being created. We want people to be in jobs. And by getting activity and a pipeline of work, and again the Labour people just can't agree that we actually want to see people in real work. And we actually want to see people out and actually developing these supermarkets and getting shovels in the ground, and that is going to create jobs and activity across New Zealand. A big thing with this piece of legislation, Mr. Speaker, is the pipeline. The government has said that we want to create a pipeline of infrastructure work that when one job finishes, you go to another job. So if we can get a pipeline of infrastructure work in the country, across the country, contractors can have confidence to go from one job to another job. So, and again, we're hearing from the opposition about employment. If we can get that pipeline, we can actually get people into work and working across the country. We want to promote a strong infrastructure development pipeline that promotes productivity. So if we actually can get these projects up and underway, we will see more work come from it. We can see contractors having the confidence to invest, and then we can have more confidence in businesses to invest more and to actually want to actually develop more work throughout New Zealand. What I can't understand, and we're hearing it through the opposition as I'm speaking today, is the no to everything. I got up earlier on today and was talking about consenting, and it's anti people that actually want to do things in this country. And on this side of the House, we actually want to see people invest, we want to see people have confidence, and we are actually backing the people that will get New Zealand moving. We don't want to hear a no attitude to everything. I've just heard from Mr. Abel, he said he's saying no to housing developments, saying no to mining, they're saying no to supermarkets, they're saying no to energy projects, they said no to fast track. They can't say no to everything. We actually need to have productivity, we actually need to have businesses working, and we need to actually have the ability to actually employ people. And if we're going to keep having a no attitude and be so negative, the economy is not going to turn around. This side of the House, this government will turn the economy around. We'll have a pipeline of work that will lead into the future, and people will have the ability to invest, and they will have confidence. And on that, Mr. Speaker, it is with great pleasure that I commend this bill to the House.
5 minute split call, Rarere Waititi.
Thank you, Mr. Speaker. I find it difficult to listen to some of the speakers in this House today. And we saw with the last speaker, he banged his mic. He thought this was going to be his mic drop moment of a speech in this House. And the only anti in this House is a government that is anti-te tiriti o Waitangi, that is anti the environment, that is anti-workers' rights. And all I have to say to Jamie Arbuckle through this speech is buckle up. Madam Speaker, what we have in this fast-track amendment bill is the public have spoken. 95% of submissions opposed this amendment bill. Every opposing submitter raised the same alarm, that the bill sidelines the tiriti o Waitangi and hands unprecedented power to ministers, Tom, Dick and Harry. The government are not fast-tracking progress, they are fast-tracking cronyism. The core issues, and what this government is obsessed with removing te tiriti o Waitangi, is the red flag. The bill replaces the tiriti partnerships with ministerial discretion. It is vehemently opposed to te tiriti. And we have seen that across many bills that have passed through this House. And now under urgency, you are urgently moving bills in this House that removes the fundamental constitutional agreement that protects Aotearoa, from corporate exploitation. And this is what this bill does. It reduces Māori to optional consultees, deepening Crown dominance, meaning ministers can approve or decline projects without recognising iwi, hapu, or honouring te tiriti o Waitangi. This reverses decades of legal precedents, including MACA Act, EEZ Act, RMA, and the 2021 Supreme Court on the Trans-Tasman Resource Seabed Mining decision. Iwi feedback and all iwi submitters oppose the fast-track amendment bill. Ngāti Ruanui, Ngā Ruahine, Ngāti Toa, Waikato Tainui, Buupoko, Ngāti Kuku, Ngāti Whakau e ki Maketu, Te Runanga o Tākau, Ngāti Rangi, Ngāti Hauahapu, Patuhara Keke Te Iwi Trust, Ngā Rauru, Ngāti Maru, Ngāti Tahu, Taranaki Iwi, Te Atiawa, Te Nehe Nehe Nui, Ngāti Manawa, Ngāti Rārua, Ngāti Kuia, Te Tōpuni e Ngā Rahu Trust. The government cannot erase Māori from the law just because we are inconvenient to your investors. This is what this bill does. It sidelines Māori from decisions about whenua and moana, reopens extractive industries already rejected by courts and by iwi. It ignores tikanga, customary rights, and treaty settlements. Loss of Māori voice and participation. The bill restricts who can submit, it limits hearings rights, it compresses timeframes, reduces opportunities for appeal. Hapu and whānau directly affected are locked out of decisions where Māori once exercised kaitiakitanga. This bill silences them. The process now privileges corporate applicants over communities, defending taiao and heritage. Māori Ward Council warned Manawatu has 10 hapu still unsettled and lacking treaty settlement protections. Te whānau Apunui are the same. Te Tai Tokerau are the same. The bill leaves them exposed to decisions made without consent or involvement. What we have, Madam Speaker, is a constitutional overreach that concentrates power in ministers, removes Māori from decision making, dismantles tiriti protections, sacrifices whenua and moana for short-term corporate gain. We stand firmly with iwi hapu whānau communities across Aotearoa opposing this bill, and will repeal this bill and entrench te tiriti. This is not fast track, it is a fast trick. A trick that hands power to ministers and corporations while stripping power from Māori communities. The government can silence us in this legislation, but they cannot silence us in this House or across Aotearoa. Thank you, Mr. Speaker.
Lan Farm.
Thank you, Mr. Speaker. I wonder what kind of new misery this is. Because we have been in this situation in Aotearoa, New Zealand, for decades of governance where some duty of care was owed to the environment. And again, we are reaching new levels of dismissal. And I want to make it really clear that the original fast track approvals bill was already completely unacceptable in its overreach. It was already completely undermining communities' democratic participation. It was overriding the Crown's very clear obligations to iwi and hapu under te tiriti, and it's weakening environmental laws and protections. That's already unacceptable. But now, if that wasn't enough for this government that want to push things out so far that these processes that we've been accustomed to in this country that have some form of legitimacy and legal standing no longer apply with this. This has pushed it out so far, it gives more weight and more strength to our very clear position as Te Pāti Kakariki that we will revoke consents when it comes to coal mining, seabed mining, and gold mining in particular, because of how egregious it is that they sidestep these environmental protections. And I want to also touch on some comments that we heard earlier from the ACT member about a lack of an argument from the hard left for being against this bill. And I want to start with a submitter that we heard in the select committee process that is not from the hard left. They're an independent fast track panel convener who is independent of the Environmental Protection Authority, who actually appoints experts to these panels. And what they said was they warned the committee to, quote, be alert for unintended policy outcomes and to proceed with caution here. Quote, impractical, unworkable changes will simply concentrate pressure on panels Were this to happen, the quality of some decisions will be very vulnerable to appeal and judicial review. Now, why that is so critical that this government actually listened to those conveners is because they hold up the integrity of the very process that these decisions are made under. And what they said that this bill does is it threatens the reputation of these independent panel members that sit on these panels to make these decisions. This is how extreme this bill is, and unfortunately, from the little we've been able to make of the short time we've had to look at this amendment paper, it doesn't look like the government's listened.
Nope.
So what that means is that this process is going to be somewhat, if not completely illegitimate, when it comes to these decisions having to stand up to appeals, having to stand up in the courts. And I think that should be of serious concern to this government. And yet they're not listening. So be it. Let's push this through today like they're going to. Any government that pushes through a bill that departs so significantly and irresponsibly from these long-held democratic legal safeguards and threatens political influence in independent decision-making under urgency needs to be challenged, it needs to be called out, and 95% of New Zealanders who submitted on this bill called it out. They said, we do not want this bill, and surprise, surprise, it's going through because the applicants, past and present, have gotten in the minister's ears. It's completely unacceptable and we oppose it.
Catherine Weir.
Look, it's really sad to hear on that side of the House the culture of no, 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 slow, slow, slow. When on this side of the House, we are wanting development. We're wanting the housing developments, the renewable energy that we so desperately need, powering up our growers and our farmers so that we can strengthen this economy and create jobs and opportunities. And look, when it comes to supermarkets, we need to create more supermarket competition so that we can reduce the cost of living for hard-working New Zealanders out there. And this is what this bill is all about. Look, I would just like to take this opportunity as chair of the Select Committee to just thank our members for the fast process that we took with this bill to obviously get it through to its second reading here today, because it is about getting more competition into our supermarket sector, and we know that we need to get things built faster in this country. We need to get the consenting regime and our planning regime a lot more streamlined and effective. And this is what this bill is about, as well as obviously making some technical changes to the fast-track process just to make it more effective and more streamlined. And it was actually very good to hear from the fast-track panel during the Select Committee process, whereby they said it was running very smoothly, it was going well, and they did actually mention some of those great projects that have already been passed, which of course is the Port of Auckland, Bledisloe North Wharf, and the Ferguson Berth extension, as well as the Maitahi Village development in Nelson, and of course the Milldale development. So these are all positive, and we want to see more of these fast-track projects are being approved. And of course, during the process, we heard from the Port of Tauranga. And this bill, of course, will ensure that we can get that Stella Passage and that wharf at Tauranga built and constructed. And why is this important? Well, this is important because at the moment, the Port of Tauranga is turning away ships, turning away our New Zealand exports, our kiwi fruit, our apples and our red meat, when actually we can be welcoming those ships and getting that produce off to market, getting the value for the New Zealand economy and strengthening our economy. So it was good to hear the reality of the situation that we're in with the Port of Tauranga. I visited them actually recently, and I could see the potential from our largest port, which obviously needs to get some wharf built, expand that wharf, and obviously welcome the ships in so that we can get more exports and grow our economy. We also heard from the Tuki Tuki water storage scheme, which of course is very, very important for my own region of Hawke's Bay, where we're actually seeing 37-degree days at the moment in Hawke's Bay. It is so hot. We've got drought on the back door, we've got drier summers, and we don't have water storage. Yet we are one of the most productive regions in the country. And so the Tuki Tuki water storage scheme is very, very important to growing our economy in Hawke's Bay, but actually growing what we already have there. And of course, supporting many jobs and opportunities in the region. And so, of course, that project is on the fast track at the moment. And so this, of course, will be very important for Hawke's Bay, because it's going to unleash economic potential in our region. It's going to diverse the land use that we have at the moment across the Heretaunga Plains, across the Ruataniwha Plains. This is a very, very important project, and with climate change on our door, with droughts on our door and drier summers, we need water storage. So that is very important. And of course, during the process, we also heard from the energy companies, and it was very interesting to hear from the energy companies, because they said one of the most restrictive barriers to bringing renewable energy online at the moment is the consenting process, because they cannot get it online fast enough. And look, I'll give an example. Recently I was up at Te Pahui with my wonderful colleague, Napier MP Katie Nimmin. Welcome back to the house, Katie. It's great to have you back. Look, and we were up there opening this wind farm. It took 20 years to get this wind farm constructed. It was 2 years to build it. So this balance is absolutely out of whack. We need to bring renewable energy on a lot faster and more efficiently. And this is what Fast Track is all about. It's about getting renewable energy projects built faster and more efficiently. And look, the last element that I just want to talk about was the retirement villages, actually, who we heard about through the select committee process, because of course we've got an ageing population and we are wanting to encourage more development in our retirement village sector. And they said that one of the biggest barriers to getting retirement villages built in New Zealand was the consenting process. And of course, when you see large investment like this, you need certainty when we're going to get that capital investment into the country and we're going to get these retirement villages built, which of course is very important to addressing our ageing population. And so having Fast Track provides the fast lane to getting these projects built, and they are so important for strengthening our economy, creating jobs and opportunities across New Zealand. So I commend this bill to the House.
The Honourable Priyanka Radhakrishnan.
Thank you, Mr. Speaker. It is so incredibly frustrating sitting here and listening to speeches from members on the government benches who wax lyrical about how their government wants to strengthen the economy, create more jobs, they'll build a whole bunch of things. But the reality, Mr. Speaker, is that they've built absolutely nothing. And because of their decisions, 20,000 jobs in the construction sector alone have been lost in New Zealand. So it is incredibly frustrating to listen to members who talk about wanting to build things, wanting to support the construction industry, when everything that they've done goes against even that. They also talk about the need for a faster consenting process, Mr. Speaker. No one's denying that. No one's denying that we need to build things better and faster, that we need a strong economy. What is frustrating is the idea presented by members on the government benches that the economy and the environment are in opposition, because that is a false dichotomy. We absolutely need a healthy environment if we're going to build a sustainable and strong economy. And that is the point that members opposite seem to fail to understand, because the chair of the Environment Select Committee stands up and talks about development, not once mentioning how this bill will absolutely ruin and put in decline the environmental protections that we need in this country. The original fast-track approvals bill was described as an assault on the environment and on environmental protections. That was absolutely correct. 20,000 people marched down Queen Street in opposition to that bill because they felt that it was ministerial overreach. It was a government that would dictate what happens when it comes to development at the detriment of the environment. And so then this government made a couple of changes. Okay, so 3 ministers would no longer be able to veto the decisions of the panel that they themselves put in place, but instead the panel would have the ultimate decision. And then now what happens, Mr. Speaker? They have a piece of legislation that they claim will be all about increasing supermarket competition, but it's not. Because there are about 100 other changes in this piece of legislation that they describe as technical, small changes, rats and mice, nothing to see here, because it's all about supermarket competition, Mr. Speaker. If that were the case, we would be supporting this bill. But it's not the case, is it? This bill is a Trojan horse. It pretends to be about supermarket competition. The word supermarket is mentioned, what, once, maybe twice? Groceries is mentioned once, maybe twice in this bill. But what does this bill actually do? And I'm going to quote the Parliamentary Commissioner for the Environment here, Simon Upton, because I think he puts it very clearly when he says that the effect of the bill will almost certainly undermine the legitimacy of the fast-track process, the robustness of its decisions, because it seeks to make the approval of applications almost inevitable by providing the Minister with a mechanism to insert tailor-made government policy statements to which weight must be given by the panels. And I want to touch on that. We have laid it out very clearly in the Labour Party differing view in the Select Committee report. It is a shame that the chair of the Select Committee didn't bother to mention this point that was raised by so many submitters in the very short period of time, given the unilateral decision by the chair to shorten the submission process. Parliament did not have the opportunity to debate that as we usually would. Labour members on the Select Committee put up a bit of a fight, well, quite the fight, over the process because it is so undemocratic, and yet, unfortunately, the Environment Select Committee chose to go with the chair's unilateral decision. Despite that, Mr. Speaker, there were a number of submissions on this very point. The bill introduces a new type of document that is relevant for decision makers, and it is the undefined government policy statement, or the GPS. Now, this GPS is discretionary. There is absolutely no criteria that is laid out for what the government policy statement should entail. There is no specified process for the development of the GPS. There is just the requirement for the minister to come up with this GPS. It can be whatever the minister decides to put in it and as wide as the minister wants to go. And the only requirement is to consult with other ministers and then to publish it. So this means that the GPS could be really anything. And if that had been confined to supermarket competition, as this government claims the bill is about, then we would have had no problems with supporting that. Because on this side of the House, we do want to see progress. We do want to see development. We want to see a strong economy as well, but not at the expense of a healthy environment as well. And we struck that balance with our fast-track bill. But unfortunately, we've got a government who doesn't care about the environment, runs roughshod over it, brings in a bill that was egregious, that tens of thousands of people marched on the streets against. They changed it in response, and now they want to change it back by stealth, because that's what this bill does. It goes towards concentrating power in the hands of the minister through this GPS. It severely limits the participation of third parties. We've heard that through a number of submissions from environmental NGOs, from conservation groups who submitted to the Environment Select Committee process. And many of them pointed out what also the PCE, the Parliamentary Commissioner for the Environment, has said. It speeds up the process that already makes, he says, that already makes heroic claims on the ability of parties to assemble material to the point that proper scrutiny cannot be reliably undertaken. And I want to point at this juncture, Mr. Speaker, to a couple of projects that have initially applied through the fast-track approvals process. Things like the open cast mine on Denniston Plateau. The Denniston Plateau is a unique ecosystem in New Zealand. It's a hotbed of plant biodiversity and bird life as well. There is a project for open cast mining on the Denniston Plateau. The Tukuha coal mine out on Westport, Mr. Speaker, rejected by the Environment Court in 2020, brought back, taken to Supreme Court, rejected by the Supreme Court in 2023, reapplied under the fast-track approvals process, and it was returned by the panel because it raised serious concerns there. So the panel, the fast-track panel, and its ability to be able to invite commentary by the likes of conservation groups like Forest and Bird adds rigour to the process, Mr. Speaker, and that is the process that this government seeks to undermine through this bill, which is ostensibly about supermarket competition. And it's not. It restricts the discretion to invite comment. It brings in a whole number of steps that need... So for a government that seems to hate regulation, when it's convenient to them and they want to bring in red tape to slow down the processes of the fast-track panel and the rigour with which the panel can operate, it does that. No problems. We'll bring in a whole bunch of extra steps there and we'll reduce their ability to make robust decisions. The panel convener submitted on this, Mr. Speaker, on this very point. We heard that the timeframes are too short. It was interesting, even the applicants of fast-track projects, many of them who submitted to the Select Committee made this point, that the required timeframes that are now reduced within this piece of legislation is too short. So it's egregious from the point of environmental protections. It's not particularly good enough even from the point of applicants. It's a pretty bad piece of lawmaking that this government is bringing in. The final point that I want to make is the fact that Shane Jones has waxed lyrical and has been very public in his criticism of the Environmental Protections Authority, the EPA. He's called for the fresh limitations on appeal rights and the ability of the government to give a general direction to the EPA as particular importance in this piece of legislation. And that's what this bill does. It inserts a new section that allows the Minister to give general direction to the EPA in relation to its performance and its exercise of its functions, duties and powers under the Act. We are concerned that this administrative role of the EPA is not being respected and that the Minister could very well interfere in the decision-making process. And so, Mr. Speaker, I end where I began. 20,000 people marched on Queen Street because of the ministerial overreach in the original bill. That was changed and it is now being brought back through stealth, through this very bill that the government claims is about supermarket competition and is absolutely not. And for that reason, Mr. Speaker, we don't commend this bill to the House.
Grant McCullum.
Thank you, Mr. Speaker. Well, earlier this year, our Prime Minister, in the State of the Nation speech, talked about the culture of no that was encompassing this country. It did develop. It's what we had become known for. In fact, I'll give you an example of how that culture of no has made it international. Recently, the CEO of the Ports of Auckland, Roger Gray, was overseas in a cruise ship at a cruise industry conference, and he said, "Why will you not come to New Zealand?" He's asking the cruise liners people, owners and so forth. They said, well, actually, we don't call you New Zealand, we call you No Zealand. That was the quote. That is an absolute disgrace. It's a sad reflection of where we have got to as a country, right? It's about, well, clearly the opposition are not interested in tourism. They don't want tourism. They don't want tourists. They don't want things happening. Listen to them. You know, they're quite happy to live in this bubble that exists in a special place that no one else wants to live. So, and what, a lot of nonsense coming from the other side is normal. But so, look, and so that was a really sad story, Now, about supermarkets, it's interesting, you know. They say, oh, yeah, we support the supermarkets, we'd support that bit. Well, really, it's interesting. When we were in the select committee, the mayor of the Far North, Moku Tapania, he was asked, he was speaking, and I asked him the question, is this important for the Far North, the improvement of reduction of restrictions for opening a supermarket? He said, absolutely. You know why? It was about grocery prices, and it was about the town of Kaitaia. It was about the town of Kaitaia, he highlighted, where there is one supermarket, and the council up there, the Far North District Council, is very, very keen to see some competition. So the people of the Far North get the opportunity to choose and have better grocery prices. A really, really important thing. Now, look, there's something I'd really like to address in this in my call, and that is the disgraceful stand of the Greens in terms of wanting to cancel consents. Absolute disgrace. So they're saying to people who come and invest in this country, and they build and they create jobs, we're just going to take that consent away and stop it, and just stop it. That is a disgrace. It's a sad reflection on the Green Party. The Green Party of Rod Donald would never have done that. The Green Party of the people gone past would never have done that. That is a disgrace, because we as a country need to be responsible players in the global sector if we are to be taken seriously and attract the investment to create jobs. So the Greens, you are a disgrace and a sad reflection on parties before. I commend this bill.
5-minute split call, Kushla Tangeri Manuel.
Tēnā koe e te māngai o te whare mai, how the mood has changed since the emergency management bill. Hoi anō rā, tēnei te miha te kia koe kei tēnei mai hoki mai. Aotearoa kia Matara. We received 2,518 written submissions on this in the small window of 10 days, and 95% of you opposed this bill, and this government don't care. They don't care about your voice, and they are taking us backwards. If they're going to give you 10 days to consult on this, imagine what they're going to do when the bulldozers come into your town. Will you be there? Will you know about it? Perhaps, because you will be notified. Mr. Speaker, this is one of the bills that sends shivers down the spines of constituents throughout Ikaroa Rāwhiti, and especially the East Coast. When considering this, my mind went back to the early 2000s when the East Cape rose and activated against seabed mining, drilling. That's going to happen again, but it shouldn't have to if, in fact, this government takes heed and actually takes the collaborative approach they are espousing to take. One of the main issues here is kaitiakitanga. One of the members opposite has said, oh, they're talking about things we can't see, touch and feel. Ko hekurangi te maunga, ko waiapu te awa, ko Ngāti Parau te iwi, no rangitukia awau. Those are all things we can see, touch and feel. But what you can't see, touch and feel is the connection as kaitiaki. That in fact is invisible. And that's why this is so important, because we get one go at this. Our whenua, our awa and our moana have to endure forever. Whonga uri whakaheke. There's been a lot of talk about property rights, Mr. Speaker, and I'm sure everyone understands here that most general land can be bought, sold, developed at will. But whenua Māori and ture whenua Māori is often multiply owned, has all sorts of different interests according to whakapapa. Now these are not going to be, these are going to be voluntarily considered under this bill. Don't just take my word for it. I took the opportunity to read some of the submissions from Ikaroa Rāwhiti and the submission of Te Hungaroia Māori o Aotearoa, who absolutely support the whakaaro of my colleagues on this side of the House. Te Hungaroia Māori warn that this bill materially reduces the practical ability of Māori to exercise rangatiratanga. While we know that doesn't matter to this government, the exercising of rangatiratanga, that's why they're trying to delete it from every legislation in this country. It diminishes Te Treaty Partnership, it curtails natural justice, and it permits executive overreach. I'm having a bit of an internal giggle because there's someone on that side trying to say my speech. But furthermore, local and regional councils have concerns about this. Greater Wellington Regional Council stated in their submission that this will erode the ability of iwi and hapu, like Te Awa Kairangi, Te Whanganui Atara, which for those of you who don't know is where we are, Te Awarua o Porirua, Wairarapa Moana and Kapiti Coast wetlands. The Upper Hutt City Council is deeply troubled by the removal of meaningful consultation. They state, quote, meaningful consultation is replaced with, quote, notice in writing and only 20 working days notification. That's despicable. So, Mr. Speaker, I know that one of the intentions, claimed intentions, is that this will bring all the voices together. Iwi, councils, hapu, landowners. But in fact, as my colleague Priyanka Radhakrishnan said, this is actually a Trojan horse. This is trickery in disguise. The genuine intention will not be honoured. We can move forward in a collaborative way, Mr. Speaker, if every voice is counted as genuine and people are not treated as Tom, Dick and Harry. When 95% of submitters make a statement, surely that is valid to be listened to, Mr. Speaker. We do not commend this bill to the House.
Katie Nimon.
Good to be back. And look, I appreciate all the acknowledgement, especially from my East Coast colleagues. We're all lined up here and in good order. Look, I just want to talk about supermarkets. We've talked about them a little bit. I think that it's actually really important to make this point. And we love a good pun, right? While in this particular bill, supermarkets can't take themselves through self-checkout, they can go through the express lane. And I just need to take you back to Hawke's Bay and the farcical situation that we've had in Hawke's Bay that does not help one single person get a more affordable grocery basket. Now, you want to build a new supermarket in Hawke's Bay. Do you think that you could do it in the middle of Napier? No, because Countdown have 2 Countdowns across the road from each other. In fact, right by my office, and it's actually a real tourist attraction. You can't build a new supermarket anywhere else in the area because, of course, all the plans disallow it. And there's another little story in Catherine's electorate, no less, where my family used to have a bus company, got sold to a supermarket. They couldn't get consent to build a supermarket. And so, of course, because they didn't want to sell the land to another supermarket because, heaven forbid, they could get the consent. There might be some competition. So they divided it up into 4 different titles so that nobody could ever build a supermarket. They had to do some different trades around and potentially trade the land with someone else so that they could build a supermarket where there was consent to be able to operate a supermarket. Oh my goodness, the lengths we go to build a supermarket to bring in competition. Now, I don't think that it's going to work if the same people just expand and, build a bigger supermarket. We need new people. We need to be able to build something new where we don't already have it. Do you think that we could do that any faster than we build wind farms, as my colleague Catherine Wedd mentioned earlier? No. We can't expect the existing operators to decide between themselves that they're going to make groceries more affordable. We need new people to come in. Yes, we're getting a second bigger Costco. Do you know how long that took them? It's absolutely unreasonable. So this bill is a very, very necessary amendment. We need to add things to the fast track bill. We see it working. And when it's working, we need to expand it to make sure that every single competitor that needs to be in this market is able to operate. So if we can make sure that the consent is available, we can fast track it by up to 6 weeks in some cases to get the very necessary building to happen. We've just opened IKEA. You can go and get meatballs at Auckland. Furniture that was far less affordable. We're talking about the grocery prices. But this goes far beyond that, and my colleagues have talked about it as well. It's a very, very important amendment to make. I think members opposite are far dramatising some of the very, very practical decisions that are being made here and bring on the RMA reform that has been introduced, and it is going to make a massive big difference to our economic recovery, to our economic growth, growing the pie in New Zealand, because that is what this is all about. We are absolutely supportive of economic growth, and that is what we are here to do. Make no mistake, I commend this bill to the House.
Glenn Bennett.
Speaker, and it's interesting to listen to what has been said across the House this morning, and the previous speaker talking about her two Woolworths in Napier, and lovely, wonderful. But the thing is, where are supermarkets mentioned in this bill? If I look through, not once do I see supermarkets actually mentioned in the bill, not once. Yes, groceries. Oh yes, they were mentioned one time, just once, and that was the only time that groceries was mentioned in this bill. So as we look at some of the rhetoric that's come out this morning, we've got to look at what it actually is, Mr. Speaker. And I think this is a fast track to yet again undermining our environment. It's a fast track to yet again undermining democracy. We look at the process we went through, and it was a challenging process, Mr. Speaker. And so therefore we cannot support this bill. In fact, we need to stand up and we need to oppose it. Mr. Speaker, we do not commend this bill to the House.
Ryan Hamilton.
Thank you, Mr. Speaker. It's great to speak to this amendment bill and the fast track amendment. Mr. Speaker, there was some resistance to the fast track amendment bill when we brought it in, and we actually got to hear from the EPA during the select committee process. And I think it was the CEO, Mr. Speaker, said that she had some reservations, she had some concerns. And in fact, the Parliamentary Commissioner for the Environment, do you remember that, Rachel Brooker? You were there. The Parliamentary Commissioner for the Environment, Simon Upton, he said he also had some concerns, but he was actually pleasantly surprised by the way the process has been going. And I think we've had 5 approvals so far, but quite a few more in the pipeline yet to come, which is really a good indication, Mr. Speaker, that it's actually working quite well. And I guess the intention of this bill was to, to enhance those aspects where it wasn't working so well, to streamline some of that process. And that's really the intent of this bill, Mr. Speaker. But also, of course, the supermarket aspect of it as well was really important. And there's been a little bit of talk about from the opposition that we haven't talked much about supermarkets, but it's actually a really integral part of it. And the former speaker, Katie, actually just mentioned Costco and IKEA, which we've been talking about New Zealand for a long time. And Mr. Speaker, those things are really important for not only the economic benefit of New Zealand in terms of the employment they bring, but of course also the wider impact they bring to the competition sector and offering a cheaper deal for New Zealanders. And so we're really excited about that. And in fact, recently, Mr. Speaker, I had the privilege of going on a parliamentary trip to Canada, and I got to go with some of my colleagues, David McLeod, and in fact Tracy McLennan from Labour as well, and a Green Party member, Huhana Linden. And Mr. Speaker, the reason why I tell that story related to this particular amendment bill is we sat down in Manitoba and talked to some of the First Nations chiefs, because as you'd appreciate, Mr. Speaker, they have challenges similar to us or parallel to us with their First Nations people, and for us obviously Māori, iwi, and they were very interested in our treaty settlements, and particularly with this fast track bill and how the implications play out legally, and of course the intricacies of treaty settlements and te tiriti, which the Green Party member spoke about earlier, as did Rawiri Waititi. And Mr. Speaker, David McLeod asked them how long it takes them to consent a project in Canada. And of course, the First Nations chief said, well, it depends on the project. Obviously, there's different complexity and nuance with every project that we come across. But David said, as an example, just a general, big project to consent, and the First Nations chief said about 2 years. And Mr. Speaker, that was quite an eye-opener for us, because our fast track would be doing well if we approve things within 2 years, Mr. Speaker. But that was an example of just how slow we take to do things. And Catherine Wedd, we have got safeguards too, Ingrid Leary. That's right. But our chair was referring earlier, Mr. Speaker, to a wind farm in Hawke's Bay, which took about 2 years or 3 years to build, but 20 years to consent, Mr. Speaker. And it's just not sustainable anymore for us to do that. And that's why we're making some big changes. And of course, the macro changes around RMA are key to that and key to this in terms of streamlining the process. But this amendment paper specifically is around improving that fast-track process. We have looked at truncating some of the turnaround time for the, for submitters when they approach, make a consent. We tried to maybe fast-track the fast-track, and there was a bit of pushback from the EPA, from the Parliamentary Commissioner and some submitters, and I believe that the Minister is considering an amendment in the Committee of the Whole where we will actually adjust that. So we had some comments from the opposition that we weren't listening, but Mr. Speaker, the Minister is listening. That select process, although it was quite quick, it still enabled a good, and efficient. Mr. Speaker, we had submitters present to us here in Wellington, and of course during the recess week we also held Zoom meetings and heard from some other submitters as well, which was really important. Just on the supermarket, one of the, the precedents we've seen, for example, many of you will know about Halswell in Christchurch. Did I say that right, Vanessa? Halswell. In Christchurch, Mr. Speaker, where Woolworths took 4 years to get a resource consent, and so they effectively said it's a multi-year, multi-million-dollar barrier. And of course, those costs, when we're talking about the price of butter, the price of cheese, those costs to set up the infrastructure to house the very thing that we're trying to increase competition has to be passed on. And so that $4 million of resource consenting, you can imagine how many percentile increments on 500 grams of butter that's going to be passed out. And so again, that's a really good example. And another example is the Waido in Pack and Save that took nearly, some commentators say it took nearly 2 decades to consent, because the resource consent actually got declined twice, Mr. Speaker. Such was the process. And that was a really quite a drawn-out example, Mr. Speaker. But what this tells us is that New Zealand is just not attractive for these big supermarket players. In fact, there was another one in Rolleston, Levi Road, Selwyn, Pack and Save, where the rezoning and the resource consents just took too long. Consent was eventually granted, but the project needed to proceed to construction, but only after very lengthy consenting, plan change interaction and with the council. In fact, there was another one, Mr. Speaker, Pioneer Countdown in Palmerston North. Timeline again, it was a proposed $16 million new supermarket, but the application was refused by independent commissioners for failing to meet urban design integration risks. That's right, Mr. Speaker, a supermarket in Palmerston North, not necessarily known for its urban design, potentially. I don't want to speak out of, I don't think there's any MPs from Palmerston North here, Mr. Speaker, but failing to meet because of urban design and integration rules. The consent was refused. What about Central Intago, Mr. Speaker? Anyone here from Alexandra? Proposed countdown in 2020. The planner recommended a decline of a new countdown because of adverse effects. Urban, traffic and amenity. Again, amenity. This is a supermarket that's not designed to look particularly sexy, Mr. Speaker. They're designed to sell baked beans, butter, milk and bread. And it was declined. The outcome recommendation against consent. Hamilton's got some new supermarkets, but actually thank you for mentioning Hamilton. Mr. Speaker, if you will indulge me, it is the city of the future. It is the fastest growing city. We have got international flights, but we have got a pack and save being built. But the council made them significant traffic management, which Pack and Save had to pay for, which is fair enough from the ratepayer perspective. But it's so much cost that the Pack and Save has to incur, and that cost is going to be passed on. So, Rachel Brooking, when you come through on the 110 Expressway from Auckland, listening to cruise control, if you want to stop into that Pack and Save, the price of butter just went up, unfortunately, because they need to pass on that cost. And so this is really the intent. Yes, that's what I'm saying, Rachel Brooking. Because if the capital cost is reduced, because the resource consent is more streamlined and easier, they don't have to pay for what, sorry? It's going to be much more, okay, it's going to be much more streamlined. So it will be much more streamlined, and therefore that cost saving and cost efficiency will be able to pass on to the voter. Mr. Speaker, I commend the bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Action New Zealand. New Zealand First.
In favour.
Te Pāti Māori.
E whā ngā poti whakahe.
Tāku Te Wharis.
Kotaki te poti whakahe.
Marea Mino Kapakingi.
Kotaki ngā poti, te poti whakahe.
The ayes are 68, the noes are 55. The question is agreed.
Fast Track Approvals Amendment Bill, second reading.
This bill is set down for committee stage immediately. I declare the House in committee at the conclusion of question time. So the House will now break for lunch and we will be in committee at the end of question time.